Well, good afternoon, folks. My name is Dan Viets. Welcome to the Spring 2026 Missouri Normal State Conference. Good afternoon, folks. My name is Dan Viets. I want to welcome you to the spring. Good afternoon, folks. My name is Dan Viets. Welcome to the Spring 2026 Missouri Normal State Conference. Well, we'll have to. Good afternoon, folks. My name is Dan Viets. I want to welcome you to the spring. Good afternoon, folks. Well, we may have some technical issues, but we think we've got a far better technological setup here for this event. We've been attempting to use Facebook for the past few years on these online conferences, which began basically during COVID, but which have been very successful in terms of the number of people who have access to these presentations. Our in-person conferences, which we've held since 1975 here in Missouri, typically drew a couple hundred people, a few hundred if we were lucky. But the online conferences have been viewed, at least in part, by thousands of people consistently. 6,000 to 10,000 people have viewed at least a portion of the presentations on these conferences. And frankly, that's why we've continued to do them. We hope you agree that NORML is fulfilling a valuable and important mission by sharing information with cannabis consumers. And NORML's role is to represent cannabis consumers. We are friends and allies in most cases with the cannabis industry in Missouri. We've worked closely with the cannabis industry to bring about legalization of marijuana in Missouri. But there are times when the interests of the industry and the interests of consumers diverge. And it is especially at those times that NORML fulfills an important role. We are very fortunate to have with us today many very highly qualified national stature speakers, as well as state speakers, very well-informed folks. We're going to attempt to respond to questions. I'm going to see if I can figure out how to access the questions which may come in on the chat, in the chat. So if you're able to access that, I'll be watching for questions and comments and relay those questions to our speakers. Now, our speakers will begin in just a few minutes with representatives of the NORML chapters around the state of Missouri. We'll be hearing from Cecil King with the Greater St. Louis chapter. They don't really mean they're greater. Of course, they mean they encompass a larger geographic area than just St. Louis. At least that's what they tell me. And Cecil King has been a stalwart, a very valuable, reliable, dependable activist and leader of the St. Louis NORML chapter for many years. We're very fortunate to have Cecil working with us and appreciate deeply all he does. Lance Leno fits that description as well. Lance is one of the leaders of our Mid-Missouri NORML chapter. Lance was one of the major one of the leading gatherers of signatures on our initiative, especially our initiative to place legalization of medical access to marijuana on the ballot back in 2018. And Lance and I attempt to carry on with the activities of the Mid-Missouri NORML chapter. And finally, our Kansas City chapter on the west side of the state, now led by Mark, also known as Happy Brosnahan, and George Biswell. George is the only activist I know of who's been active in Missouri as long as I have, or maybe a little longer, actually. George is a Vietnam era veteran, very active on behalf of veterans' interests and causes, especially when they concern cannabis. We're going to hear after that from Kevin Caldwell of the Marijuana Policy Project. Kevin has recently joined the staff of MPP. He has taken the place of Karen O'Keefe. Karen was actually scheduled to be a speaker at this conference a few weeks ago. And during the interim, she has left MPP. Hard for many of us to believe or accept because she's been a part of that organization for so long and a very valuable part of our movement. And we hope and expect she'll remain active in the movement, but at least for the time being, apparently not with MPP. But Kevin has likewise been active in marijuana law reform for many, many years. He presently resides down in Louisiana. And he is the coordinator of state policies for MPP. So there's probably no one better qualified to tell us what's been going on in the states in recent weeks and months. Many, if not most, of the state legislatures around the country follow the same pattern that Missouri's General Assembly does in terms of scheduling. That is to say, the General Assembly here and in many states cranks up the first week of January each year. And continues through the second Friday in May, typically. And so there's a lot of legislating that takes part during the final weeks of the session each year here, as well as across the nation. Kevin will give us an overview of that. At 2 p.m., we'll have with us the extraordinary attorney, Joe Bondi, who presently chairs NORML's board of directors. Joe is really a great litigator, and I continue to be impressed by his legal work on behalf of NORML, on behalf of NORML nationally, and we may be collaborating on some litigation here in Missouri. I'll tell you frankly that we think it may be necessary to go to court to get the municipal courts of Missouri to follow the Missouri Constitution and expunge municipal offenses. I'll talk more about that later. At 2:45, we'll be hearing from two staff members, both of them relatively new staff members at the Missouri Division of Cannabis Regulation, a subdivision of the Department of Health and Senior Services here in Missouri. When we wrote Article 14 of the Missouri Constitution, Article 14, Section 1, dealing with medical marijuana access, passed by the voters again in 2018, and Section 2 of Article 14, the adult use legalization measure passed by the voters of Missouri in 2022. Now, I know a lot of people want to continue to call them Amendment 2 and Amendment 3, but that language is not helpful. Every election, there's another Amendment 2 and Amendment 3, so it's just confusing to use those terms. Properly referred to, they are Article 14, Section 1, Section 2. And one of the things we did when we wrote Article 14 is to provide for, that is to require, the designation of a chief equity officer for the state of Missouri. Leslie Turek has recently taken that position, and I heard a presentation, excellent presentation that she gave down in Jeff City recently. She is also doing similar presentations in Kansas City and St. Louis, and I think in Springfield as well, primarily concerned with the micro business licensing. The third round of micro business licensing has just been announced. It's going to begin in just a few weeks in July. She'll talk with us in more detail about how one can engage in the process of applying to obtain a so-called micro business license in Missouri. And I've always regretted the term micro. I think that's a misleading term. These are really substantial business licenses allowing people to engage in what is often called a vertically integrated business. So you can actually cultivate cannabis, manufacture products from it, as well as engage in the retail dispensing of cannabis, depending on the licensing that you obtain. But we'll hear a great deal more about that. We'll also hear from Dr. Rika Yu, who again recently joined the DCR staff here in Missouri. Dr. Yu will talk to us about cannabis regulation under Article 14, and in particular about the operation of what's called the reference lab, a laboratory which is testing the testing labs, trying to make sure they stay honest and don't give in to the natural pressure to exaggerate THC content, or perhaps more importantly, to underreport contaminants. And that's a very important function. That's a very important reason why legalization is important, is because people can have access to cannabis which is safe and of a known potency. So testing is very important. Also, she's going to talk about the cannabis research activities, which are now being promoted as Article 14 requires, opportunities for serious scholarly research to be done on cannabis here in Missouri is part of Article 14, and Dr. Yu will tell us more about that. Well, at 3:30 p.m., unfortunately, we won't have with us Representative David Tyson Smith or Representative Greg Bush or Representative Adrian Plank. So you'll probably be hearing more from me for about 30 minutes there. I will try to cover some of the topics that they would have covered. Some of the bills that passed this year, both good and bad, and there were some good ones and there were some terrible ones. For the most part, the terrible ones are not going to affect cannabis consumers, but nonetheless, there are still people being sent to prison for marijuana offenses in Missouri. And one doesn't have to try very hard to violate the law concerning cannabis in Missouri. Those who continue to engage in illicit or unlicensed cannabis cultivation, distribution, and so forth are definitely still subject to prosecution. At any rate, it's important that we keep on top of the legislation that is pending and passed in Jefferson City, and I'll do my best to fill in, talk about some other topics as well during those 30 minutes. At 4 p.m., we're going to hear from Craig Katz, an attorney who represents the Missouri Hemp Trade Association. And that's one of the most, I think, interesting and exciting areas of public policy recently. The licensed cannabis industry, MoCan Trade here in Missouri, and other similar organizations and entities that represent the licensed legal cannabis industry have across the nation fought to suppress and ban the sale of hemp-derived intoxicating products. That's kind of a mouthful, but that's the most accurate description, I think, of what we're talking about. The sale of hemp-derived intoxicating products has now been limited under a bill that MoCan Trade succeeded in getting passed this year. They tried to get it passed for the past couple of years at least. Meanwhile, the Missouri Hemp Trade Association had other legislation pending, which would have imposed the regulations that MoCan Trade claimed they wanted. The concerns that some legislators claimed they had were addressed directly by bills which were sponsored by, which were promoted by the Missouri Hemp Trade Association. But and of course, as most of you probably know, when the last government so-called shutdown was resolved, the Trump administration managed to sneak into that legislation what appeared to be a totally unrelated measure, which resulted in a federal prohibition on the distribution of hemp-derived intoxicating products to take effect on November 12th of this year federally. Well, that made it much easier for states like Missouri to pass similar bills. But now, ironically and strangely, within just the past 48 hours, the White House, read Donald J. Trump, has called for at least a delay in the implementation of that federal ban, and sounds like they are calling for federal regulation. So maybe Missouri will again follow Trump's lead. Who knows? But I'm looking forward to hearing from Craig Katz about that. At 4:30, we'll hear from Samantha Bloom, who is the statewide chair of the Missouri Microbusiness Marijuana or Microbusiness Cannabis Association. We had hoped we would have Jimmy Poe with us, but Jimmy has frankly just been unresponsive to our messages and our emails. And so I will be pleasantly surprised if Jimmy joins us, but we will have Samantha Bloom here, who can give us a perspective on the statewide status of microbusiness licensing, and we'll follow up on what Leslie Turek has to tell us about that topic earlier in the afternoon. Finally, at 5 p.m., we'll be hearing from a man I have worked with for many years and come to have great respect for. That is Morgan Fox, NORML's national political director. And Morgan is as knowledgeable as anyone in the national movement about federal marijuana legislation and litigation for that matter. So one of the topics that's upcoming, and I expect that Joe Bondi may touch on this as well, is the Trump administration holding hearings on rescheduling of cannabis. Now, if I understand correctly, state legal medical only has been rescheduled from Schedule 1 to Schedule 3. And that can have very important implications primarily for the industry. And I don't begrudge them that at all. It absolutely is appropriate that they be allowed to deduct their business expenses from the amount of income on which they pay income tax. It is outrageous and absurd that they have not been allowed to do that in the past. So at least now, as to state legal medical marijuana, they've been relieved of that burden. They are able to do what every other legal business does, deduct your business expenses. However, as to non-medical adult use and what the press insists on calling recreational marijuana, as to that aspect of the industry, hearings will be held very quickly. In fact, as soon as possibly next week, there will be hearings before the DEA, which is a subdivision of the U.S. Department of Justice, ironically enough, and they will be considering the further rescheduling of non-medical adult use marijuana. NORML filed an application to present, and it should have been granted. It was not granted. In fact, no organization which supports marijuana reform or legalization was allowed by the DEA to present. So it's going to be a parade of horribles at that hearing. About a half dozen national groups who are opposed to any form of marijuana law reform and certainly abhor any form of legalization. But again, Morgan Fox will talk to us about that at 5 p.m. And then I'll wrap it up at about 5:45. So we really appreciate you being with us. We hope you'll stay with us, but if you cannot be with us for the duration, all of these presentations are being recorded and will be available on NORML's YouTube channel, and I expect also on NORML's Facebook page in coming weeks and in relatively short order. So we are now ready to hear from Mr. Cecil King, and I think he's been admitted to the meeting, and Cecil's going to tell us about the activities of St. Louis NORML and perhaps some other topics as well. Welcome, Cecil.
Oh, thanks, Dan, for having me on.
I think he's been admitted to the meeting, and he's going to tell us about the activities.
Am I coming through okay?
Topics as well. Welcome, Cecil.
Good, thanks. I've changed my virtual background so that in celebration of the our new research licenses, which we'll hear about later today. So
I've changed my virtual background.
That was appropriate. So many thanks to Dan for putting on this spring Missouri NORML conference together. We have an exciting speaker lineup, and we also appreciate the presenters who have taken the time to appear in our spring conference here. Spring conference is it's a stretch of the definition because I think we are into June here, but it still works. The only relevant news to share about Greater St. Louis NORML is that we're looking for an executive director, and also maybe a few directors too. Over the past several years, many of our directors have migrated into the cannabis industry or into politics or other allied cannabis advocacy groups. This is absolutely great. Working with NORML, you can get an equivalent of a master's degree in cannabis policy and advocacy, cannabis law, cannabis science, genetics, and a whole bunch of other topics about the plant. So reach out if you might be interested. Greater St. Louis NORML has been around since the early 90s, long before I attended a chapter meeting way back in 2015. That was right about the time NORML advocates were starting to push for legalization in Missouri with initiative petitions. That was also, unfortunately, the time when arrests for cannabis in Missouri were running about 20,000 per year or more. Thankfully, that's not happening anymore. We've come a long way by passing medical and adult use in Missouri. Greater St. Louis NORML meets with the other NORML chapters in Kansas City and Columbia for monthly Zoom conferences. We discuss current and pending legislation and any new cannabis policy directives that affect cannabis consumers. And even though NORML is primarily an advocate for consumer cannabis rights, we have advocated to increase business licenses, mainly because more cannabis retail licenses mean more competition. Whoops, I guess I'm back here. um, we normally post relevant news and information on our Facebook page. We attended the DCR St. Louis Micro Business Educational Event and the Q&A session on June 15th in support of candidates interested in applying for the third round license lottery. The application window and lottery date have now been officially announced. You will only have a 2-week window from Monday, July 13th through Monday, July 27th to submit an application. July 13th through the 27th. The lottery will happen shortly after that on September 9th. But before you commit, there is a new major rule that will affect your application. You must complete a mandatory online training session before you submit an application. Most of this has to do with the mechanics of your application and people who will be in charge of it. So DCR, which is Division of Cannabis Regulation, wants you to be aware of the submission process and all the licensing requirements before submitting an application. DCR Social Equity Director Leslie Turek gave an excellent in-person presentation in St. Louis, like she did in Jefferson City. So she will appear later during the conference today. And her last educational event will be a webinar on this following Monday, which is Monday, June 29th. Registration is required, and we have a link on our Greater St. Louis Facebook page at facebook.com/GSTL normal. So you can go there and look at the last schedule there for this educational event. When we went to the conference with Leslie, she said that DHSS plans to issue at least 77 licenses to bring the total number of micro business licenses up to the constitutional minimum of 144 micro business licenses. So again, if you are looking for a serious entry point into the world of cannabis advocacy, by becoming a director or executive director of Greater St. Louis NORML, just feel free to reach out. Our Facebook page is, like I said, facebook.com GSTL normal. And that'll get you right there, and you can message us, and we'd like to hear from you. So that's kind of a quick synopsis there, Dan. So I think I'll just throw it back to you if you need anything else.
Hi, my name's Happy Brosnahan. I'm the new executive director for NORML KC.
And Happy, I don't think knows that I'm still speaking here, but I'm just about to wrap it up. So let's go to Happy.
Hi, my name's Happy Brosnahan. I'm the new executive director for NORML KC.
And Happy, I don't think knows that I'm still speaking here, but I'm just about to wrap it up. So let's go to Happy.
Hi, my name's Happy Brosnahan. I'm the new executive director for NORML KC.
And Happy, I don't think knows that I'm still speaking here, but I'm just about to wrap it up. So let's go to Happy.
Hi, my name's Happy Brosnahan. I'm the new executive director for NORML KC.
And Happy, I don't think knows that I'm
I
I
don't know. We're currently working to get the word out about defeating Amendment 4 in the August election. Amendment 4 is just another example of the government taking the power away from the people and pretty much effectively ending the citizen initiative process. If the Amendment 4 rules were in place whenever we did pass medical and adult use, neither one of them would have passed. So we would still be without cannabis in Missouri. So it's pretty important that everybody gets to the polls in August to vote no on Amendment 4. So that's really our largest priority right now. Other than that, our chapter's getting chapter meetings started again regularly. That'll be good to kind of let everybody know that there's a lot of work to be done still, and we're the ones that need to be doing it. Other than that, we're working on getting the language written for consumption lounge regulation, and other than that, just building numbers, getting word out about different things that we need as consumers, and if there's anything that the Kansas City consumers do need or see an injustice, we need to know about it so we can do something about it. But other than that, yeah, we're just trying to rebuild the stature of, like NORML KC, because that's all. So thank you, Dan, for putting this on, and thanks for having me on.
Happy, thank you very much. We appreciate that. We appreciate you.
So thank you, Dan, for putting this on, and
we appreciate you
thanks for
keeping the
having me
flame
on.
burning over there on the west side of the state. George Biswell, I had hoped to be able to join us, and maybe
Thank you very much. We
maybe he'll
appreciate
be
that.
on a little
Appreciate
bit
you.
later.
So thank you, Dan, for putting.
I'm still getting a bit of feedback here, so that's the primary reason for my disorientation, or maybe others as well. But at any rate, we appreciate both George and Happy and others who are remaining active for NORML on the west side of Missouri. I want to touch on a couple of points that Cecil and Happy have just made. One is that Cecil is absolutely correct. It is not spring any longer. We are aware of that. We have taken a broad definition of spring. Spring ended last weekend. We had to reschedule this conference because of a combination of technical issues and because of a medical issue that our tech guy ran into a family emergency. So actually, in some ways, I think we've been able to improve on the original lineup of speakers that were set for this event just a few weeks ago. Also, want to echo what Happy has just said about the importance of Amendment 4, the importance of defeating Amendment 4 in particular on the ballot here in Missouri on August the 4th. This is a primary election issue, and frankly, I think some of the proponents of this measure are counting on us not to go to the polls. And indeed, fewer people historically do participate in elections, in primary elections, than in general elections. In November, we'll have a general election. There'll be other important issues on that ballot. But this August 4, there is, in my opinion, no more important issue than Amendment 4, which proposes to amend the Missouri Constitution to make it essentially impossible to place a measure on the ballot, to pass a measure, I should say, which is placed on the ballot through the initiative process, and specifically constitutional amendments. We know from bitter experience that if the voters pass a statutory initiative in Missouri, and it's tempting to do that because it takes substantially fewer signatures to place a statutory initiative on the ballot, but the legislature will just turn around and undo it. By its very nature, the initiative process is there for things that the legislature won't do, doesn't want to do, or can't do, and they will undo. So it's extremely important that we preserve the option of a constitutional amendment initiative process here in Missouri. Well, it's 1:30 p.m. by the clock on my desk here at least, and that means it's time to hear from our next guest, Mr. Kevin Caldwell with the Marijuana Policy Project. Kevin is the new director of state policies there, and he's going to update us on what has been happening and what may be happening in the various state legislatures around the country. Kevin, would you introduce yourself and tell us what's going on? Muted at the moment. Kevin, can you unmute there?
Okay, thank you. I should be unmuted. Am I?
Muted at the moment. Kevin, can you unmute there?
Okay, thank you. I should be unmuted.
Yes, you are.
Am I?
Yes. Yes,
Okay.
you are.
Fantastic. Thank you very much. It is an honor and a privilege.
Okay, thank you. I
should be on this stage tonight, at least virtually, with real heroes like Dan.
Thank you very much.
It is an honor and a privilege.
Okay, thank you.
I am on this stage today. You please have to excuse me. If I look like I just came from a funeral, I did. So, but there is a lot of good news that we can talk about cannabis policy reforms on the state level in 2026. We just updated. I thought I was going to be presenting this, but on the Marijuana Policy Project site at mpp.org/states. We have our newly updated map that is up to date with all of the states with adult use and with decriminalization, medical. It is fantastic to be speaking in front of an organization that represents a free state as it relates to cannabis. And that is done by the advocacy of people in this room. And Dan, I thought, really hit it very importantly before we came in, how important it is to have the ballot initiative process to move cannabis policy reform forward. We see almost all the states that are still prohibitionist do not have the ballot initiative process. So I'm going to kind of I'm going to copy what Dan said and get out in those primary elections in August and defend the right for citizens to amend their own state constitutions. You are the show me state for a reason, and I certainly hope that you show in August the fact that you want to continue to have a voice in direct democracy. You are the show me state for a reason. And I think we're going to start. One of the biggest things that I've been excited about was this year Georgia became the 41st comprehensive medical cannabis state. That medical cannabis law goes into effect on July 1st. And because Georgia already had operational dispensaries and growers, there was no need to set that up. It's worth noting that there is no home grow in Georgia, but Senate Bill 220, the Georgia Putting Patients First Act, revised the law and included, they changed the cap. It used to be 5% THC. So now a patient, or as of July 1st, a patient will be able to legally hold 12,000 milligrams of THC. It is going to allow vaporization, including the vaporization of raw cannabis for patients 21 and only. It does not allow smoking of cannabis. It removed the language. So many of their ailments that were covered under the program in Georgia was for severe or end stages, and they removed that language from all of that. And they also added lupus as a qualifying condition. And just to let everyone know, PTSD and intractable pain were already qualifying conditions in Georgia. But I think it is so important that raw flower and vaporization of that raw flower is now allowed in the program. So particularly patients suffering from PTSD and intractable pain have a method of delivery that will allow for quick results. And I'm huge effort by the NORML chapters active in Georgia. I enjoyed working with them. The one strange aspect of the Georgia law is that it does not allow food products containing cannabis. So there was an attempt in that Senate Bill 220 to allow that, but at a certain point, it was no longer. It was that didn't make it through the legislative process. In Idaho, we should know by July 1st, whether or not the ballot initiative for Idaho is going to appear on the ballot in November. The Natural Medicine Alliance of Idaho signatures are in the process of being verified, and as of last night, I had not heard of whether or not the enough verified signatures will put this initiative on the ballot. Patients, if passed, patients will submit documentation that they've been diagnosed with what is a quote unquote substantial health condition, and that would include HIV, multiple sclerosis, ALS or Lou Gehrig's disease, anxiety, autism, insomnia, PTSD, chronic and persistent pain, and acute pain. That is a solid start for a medical program. It will allow 3 vertically integrated businesses at first and allow delivery. And if passed, dispensaries would be referred to as fulfillment centers. They would be allowed to have, a patient would be allowed to have up to 113 grams of raw cannabis per month, or products containing up to 20 grams of THC. Sadly, the Idaho ballot initiative does not include home cultivation. As y'all are very well aware of, there's been several attempts this year across the country to roll back the successes that the cannabis policy reform movement has implemented over the last 20 odd years. We just talked about Idaho putting to their citizens having a medical cannabis program, but the legislature in Idaho has put a measure on the ballot that seeks to deprive voters of the power to legalize any drug, including cannabis, via the ballot measure. So actually, our friends in Idaho are going to have both a choice to implement the medical cannabis program and at the same time make sure that the legislature is thwarted in keeping that ballot initiative process alive if the citizens of Idaho can ever gather enough signatures, verified signatures, to end prohibition completely in Idaho. Hopefully, and this is kind of a call to arms for advocates across the country, there is a very well-financed move that will very much likely be on the November 2026 ballot in Massachusetts. And prohibitionists are trying to repeal legal adult use sales and home cultivation. They were supposed to have, I believe it was a batch of 15,000 signatures submitted by June 17th. That is in the process of being verified right now. But if this makes the ballot, I'm throwing a challenge out. Listen, I live in Louisiana, but every time that we talk to people anywhere across the country, we talk to them about, hey, there is going to be through NORML, through MPP, through lots of different organizations, opportunities for advocates to remotely help defeat this deeply flawed initiative. And if you haven't been following it in the news, they have been getting people to sign, being very sketchy, saying that they're trying to improve the program. So working off of what they believe will be an electorate that is low information on this topic, and it's going to be up to advocates across the country to help defeat this attempt at a rollback at Massachusetts. And why is it that this is important? Because if the prohibitionists are successful in Massachusetts, they will most likely try in Maine in 2027, and they will most likely try in other states. For example, the Maine ballot initiative, they simply weren't able to get enough signatures, so they missed a deadline for the 2026 ballot, but they are still trying to gather signatures for 2027. But for example, I think if the cannabis community and the greater community in general comes to recognize that public health is better served by keeping cannabis behind the counter where you are familiar with the product that you're getting, and that is age gated, is the best way to contain any perceived issues with our beloved plant. There was another attempted ballot initiative in 2026. That initiative has been abandoned. It sought to repeal the legal regulated adult use cannabis market. But by education, by outreach, and reaching out to the people involved who were really, they had been convinced that youth were at risk because of legalization. Whereas we have seen repeatedly that actually, if we're concerned about youth access to cannabis, legalization is the best methodology to restrict youth to our young people. The illicit market does not ID. And it was a great news to this movement that the person who was the point person on that ballot initiative was convinced that actually youth was best served by legalization and not prohibition. So that was a victory, but I cannot underestimate the importance of defeating the Massachusetts initiative. If prohibitionists win in Massachusetts, they will become emboldened across the country. And they already have financing that dwarfs what we have access to. So I think it's important. I know I will be volunteering to help with that Massachusetts campaign. And I hope you will take that, because today it's in Massachusetts. Next year, it could be in your backyard. You know, and then there's been some rollback. Ohio Senate Bill 56 introduced, back then. For those that don't know, Ohio voters approved legalization in 2023. In late 2025, the legislature removed non-discrimination provisions for adult use consumers and recriminalized possessing cannabis obtained anywhere other than from an Ohio retailer or homegrown. And, we all do know that a lot of cannabis consumers were going across the border to Michigan where cannabis was cheaper. Transporting cannabis that is not in either its original unopened package, or if it's not stored in a trunk or a similar area away from the passenger area and driver area. And once again, possessing edibles, if they are not stored in the original packaging at all times when the products are not actively in use. And then finally, and this is going to become a recurring theme, inhaling cannabis anywhere other than a residential or agricultural property with the owner's permission, which would include like a bar's patio, a parking lot, or a smoking hotel room. And this legislation also eliminated the social equity and job programs in Class 3 growers. This shows that even in a legalization state, that it is not over once you have passed legalization. The forces opposed to us will continue to go, you're right, over and over and over again. And this was a fight. Advocates in Ohio put up a fantastic fight. But yet it was still not enough to stop this. I do not know why conservative legislators continue to try to go against the will of the people, but they continue to do so. And it is up to us to stay engaged, continue to build relationships with legislators to make sure that it doesn't happen. To you, and actually, we will talk in a minute about what a great job the Show Me State did with defeating similar legislation in Missouri. But a little closer to home to me, and I was involved distinctly in this in Louisiana, where we implemented a decriminalization law in 2019 and made it the current penalty is $100 fine for possession of up to 14 grams. The governor of Louisiana was appalled by the amount of cannabis smoke that he smelled at college football games. And so he found a willing minion who put forth legislation that imposed a mandatory jail time, including custodial arrest, with up to a 1-year maximum in jail for smoking, vaping, or otherwise abusing cannabis within 2,000 feet of any school property, and that includes universities. Just to let you know, 2,000 feet is 0.38 miles. In cities, in most suburbs, that basically recriminalizes public consumption of cannabis in entire areas. Both the House and the Senate narrowly passed this legislation. The governor was on the floor, strong arming legislators in the House. In the Senate, he was on a flight to Greenland, and he was spent the flight calling senators, threatening them to pass this legislation. It was when asked if the main threat, as he perceived it, was at college universities, we recommended amendments to the bill, and the sponsor refused to hear any amendment, including from the medical cannabis companies who were asking for a caveat to be carved out for them. And even they, who have very good relationship with the governor in Louisiana, were unable to get that legislation amended. But with rollbacks, once again, I'm going to look at what the people of Missouri and what advocates like yourself did in defeating Senate Bill 1187, which would have made consumption of public consumption of cannabis a Class B misdemeanor, punishable by up to 6 months in jail and a fine of up to $1,000 or both. Congratulations, well done. In Minnesota, advocates were able to defeat Bill 3591, which would have capped THC at 15% in flower and 30% in concentrate. You know, once again, our opponents at times can be, their ignorance toward this plant really shows. Because what is the point of capping the concentrate at 30%? Why would you want a consumer to have to consume that much more to get the desired effect, whether it was recreational or medicinal, and to have people consuming filler? It makes no sense whatsoever. In Florida, they were able to defeat House Bill 1003 and Senate Bill 1056, which would have created penalties, including criminal penalties on second and subsequent offenses for possession of an open container of both cannabis or hemp products. Arizona was able to defeat their Senate Bill 1725, which would have made it a nuisance offense to smoke cannabis on one's own property if it can be detected on another property 3 times in 30 days. It would have imposed up to 4 months in jail. And that bill passed the Senate and passed House committees, and luckily was able to not get through the floor on the House. The one big rollback that is still alive right now is New Jersey Senate Bill 3171, which would make it a crime, getting up to 6 months in jail and or a fine of up to $1,000 to buy cannabis from an unlicensed business. South Dakota attempted to eliminate the state's medical program 90 days after rescheduling. Luckily, that was universally voted down in committee. Another bill would have eliminated the affirmative defense for unregistered patients. That passed the House, but was not able to move forward in the Senate. And Senate Bill 194 would have imposed THC cap. And once again, that was defeated in committee. Nebraska, as many people may know, the citizens passed a ballot initiative for medical cannabis, the Patient Protection Act, by requiring patients to register with the state and adding burdens on recommending practitioners. Luckily, the Cannabis Commission rules gutted the initiative regulating sales, including by banning the sale of edibles, flower, or vape cannabis. And they also allowed far too little cannabis and added even more additional burden on medical professionals who would be recommended. As a side note to that is that the first plants were planted this week in Nebraska. So good news for patients there. Virginia was an exciting state I had the pleasure of working in this year, and the House and the Senate passed a bill that they had been working on for 4 years. That was initially the governor waited until it was on her desk, and she basically rewrote the bill, and the House and the Senate rejected her amendments. And they were finally able to come to an agreement, and that bill the language was added into the budget, and that budget should be signed on Monday. The governor's amendments included they wanted a recriminalization of minors and ramping up criminal penalties. And they wanted more time before adult use sales began, and she wanted to lower possession limit and fewer dispensaries. In the end, the compromise did not recriminalize possession for minors. However, it did continue the current adult public consumption fine is a $25 civil fine, but they have raised that civil fine to $650, a 900% increase. Luckily, that bill does not go into effect till July 1st, 2027. So we are hoping that our allies can bring some common sense back to penalties in the Old Dominion state before then. Yes, sales will begin July 1st, 2027. Yes, personal possession will be raised from 1 ounce to 2 ounces instead of 2.5 ounces. And there will be beginning 350 dispensaries in the Commonwealth of Virginia. Also signed into law in Virginia were bills that modified or possibly modified sentences for people either incarcerated on parole or probation for cannabis felonies. And those will be automatically reviewed beginning later this summer. And also a House Bill 942, which would end child custody non-discrimination. So in other words, parents cannot lose custody of their children based off of now legal behavior. Several states, including Colorado, Delaware, Louisiana, Oregon, Virginia, and Washington, passed what they're calling Ryan's Law, which allows terminally ill patients to access medical cannabis in health facilities. In Massachusetts, possession was personal possession limit was raised to 2 ounces. Vermont also increased its possession limit from 1 to 2 ounces. And in Iowa, increased the number of medical dispensaries from 5 to 10 and allows out-of-state patients to apply. Connecticut opted to go for a 10.75% excise tax instead of basing off of potency, and it eliminated 2 driving requirements and eliminated potency caps in concentrate. In Minnesota, an omnibus bill eliminated separate supply chains for medical and adult use cannabis, and it allows adult use retailers to sell medical cannabis. In Alaska, a crime omnibus bill that included sealing possession of up to 1 ounce became law without the governor's signatures. And in Illinois, a cannabis hemp omnibus bill doubled possession limits from 30 grams to 60 grams, allows medical patients to buy cannabis almost tax-free, allows curbside and drive-through, but also on hemp products mirrored the new federal cap of 0.4 milligrams of THC per container. There were some attempted progress in Delaware. Has made it out of committee that would remove jail time for public consumption. Massachusetts is still looking at employment protections for adult use committee, and that has made it out of committee. 7 states had or have bills to allow homegrown in adult use or medical state where it's not allowed yet. For legal states, that would include New Jersey and Washington, and in medical states, Florida, Kentucky, New Hampshire, New Jersey, Pennsylvania, and West Virginia. And also what would be theoretically the 42nd medical cannabis state was South Carolina had a 1980 law that said that medical cannabis had to be implemented post rescheduling. And it's basically saying the health director of South Carolina shall obtain marijuana through whatever means he deems most appropriate, consistent with federal law. In qualifying conditions, certain cancer patients and glaucoma patients with a life-threatening or sense-threatening situation who are not responding to conventional controlled substances. The department may also include disease groups based on data. If this is implemented, South Carolina will become the 42nd medical cannabis state in the country. Just to let you know, Senator Tom Davis has championed medical cannabis in South Carolina for 10 years. And I think there's a distinct possibility that if the 1980 law is implemented, which may be done through court action, then either the legislature may come into a special session, or most likely in 2027, the South Carolina legislature would finally pass the Compassionate Care Act. So a lot of things are continuing to go in the United States, and it's an honor to be here. It's an honor to work with our partners at NORML. And just to let you know, the Marijuana Policy Project and NORML work very closely. And, you know, but once again, we can only do so much. It's you, the advocates, that continue to make a difference in cannabis policy in both your state and all the states around you all across this country. Been an honor to speak today, and thank you very much.
Thank you, Kevin, very much. That was an excellent presentation. Our next speaker is with us, Mr. Joe Bondi. We've been experiencing an echo. We're trying to address that, and we will continue to try to eliminate that echo sound while Joe is speaking. I think our listeners can hear what's being said, and the captions, of course, assist in that, but we're aware that there's an echo. We're trying to get it eliminated. But I am pleased and proud to introduce our next speaker, my friend and my colleague, Joe Bondi, chair of the National NORML Board of Directors, an outstanding criminal defense attorney, and an outstanding civil litigator. I continue to be amazed by Joe's ability to undertake litigation of apparently all sorts, including most recently attempting to have NORML accepted as a presenter at the rescheduling hearings, which are upcoming very shortly. So I hope Joe will tell us about that, as well as about the Hamani case, in which we won a tremendous unanimous victory in the United States Supreme Court. Please welcome Mr. Joe Bondi. Got to unmute, Joe. There we go.
Gosh, thank you, Dan. Thank you so much for having me. I want to start by saying I'm incredibly grateful to be here, and I've been incredibly grateful to be a part of NORML and the National Legal Committee for 29 years now, for a long, long time. And I feel as though it's helped me tremendously. I've practiced cannabis law now, first as a criminal lawyer and now, you know, as a civil and commercial attorney mostly, for about 31 years without break and with great enthusiasm. And I love what we're doing, and I love the changes in the field, and I love some of the challenges. I'm here to talk in my capacity as principally as co-chair of the NORML Legal Committee's amicus committee, which is a friend of the court committee within the legal committee. And we file briefs in important cases involving issues that relate to cannabis. And we're on a roll, Dan. Like, I think we've won like 4 of these. At least our opinion has been accepted by the court in 4 or 5 of these instances. We're not representing a party, but we're representing a viewpoint, right? And we're doing impact litigation on points of view that I think are really very, very important. So you were one of the members of the amicus committee in Hamani and in the drafting and the filing of our brief in the U.S. Supreme Court. And I'm incredibly grateful. You gave us the revelation about the Battle of the Bales, right, in Missouri. And I thought that was really super cool because, and I thought that what we did was, I'll tell you a little about the case, but before I do that, I'm going to wax effusive about our committee because we take these cases all pro bono and we write and we work together synergistically. We make things better, like by bouncing things off each other. And lawyers can appreciate it. We go through like a lot of drafts. It's kind of like putting a pot on a wheel, right? And it's got to be really perfect because words count. And so it's been a pleasure to work on being a better lawyer in the context of our friend of the court committee. But the Himani case comes out of the Fifth Circuit, and it's a case involving a statute which is commonly referred to as 922G3. That's the number in the Title 18 of the U.S. Code that it's been ascribed. But that statute makes it a felony, a significant felony for a person who is a quote unlawful user of drugs to possess a firearm. And that statute was the subject of constitutional attacks under the Second Amendment in a variety of courts over the past couple of years, right? We took this issue in the Fifth Circuit in a case named Daniels. We took it in the 11th Circuit in a case named Cooper. And in those matters, we as NORML amici were arguing that you can't categorically ban people, cannabis users, from possessing an arm, from exercising their Second Amendment right. There had to be some kind of a showing of dangerousness, right? There had to be a showing of actual, and that was the historical precedent, right? Is historically we disarmed people who were like drunkards, right? Habitual drunkards, as the words were said, or people who were totally intoxicated in the saloon and represented a public health and safety threat on a variety of other grounds. But they always had to be really messed up, right? And we were arguing throughout these earlier cases in the different circuits that these status-based bans violate the Second Amendment, they're unconstitutional. But what became a flashpoint for us really was this Himani case, because Himani made its way through the courts, then cert was granted. And so NORML, for the first time in several years, had the opportunity to file this friend of the court brief in the United States Supreme Court. And I think we did an outstanding job in stating our position, along with other people like the NRA, other entities, right? The NRA, the Cato Institute, homeowners for guns or whatever it was called, the ACLU that represented the litigant. There were so many different entities brought together around this same point, right? This same freedom and liberty point. And our perspective was, again, you can't categorically ban people from utilizing a firearm. In our case, cannabis users, and particularly for a number of reasons. We're not even that like fucked up. Like we're not even really so intoxicated, right? But there's no evidence in the Himani case of marijuana use at the time that the feds came into Himani's home and found a firearm. The facts were a gentleman comes in through the airport. He's tied as a Pakistani to some Iranian militant group. A search of his home is executed. He's cooperated with the federal agents. They enter his home. They find about 2 ounces of cannabis. He says he uses marijuana every other day. There was no evidence of recent use or intoxication. There was no evidence of any other kind of criminal activity. I know there was a bag of cocaine in the home that was, I think, found in the mom's room, but Mr. Himani, took the weight for it, pun intended. But he was then prosecuted under this 922G3 statute, and he ended up arguing successfully in the lower courts that the statute was unconstitutional as applied because there was no evidence of him having satisfied that touchstone of actual intoxication and dangerousness at the time that he was in possession of this gun, which I think was even in another location. And the Supreme Court heard from all these amici that had oral arguments several months ago. When our conference was originally scheduled, there was no decision. But last week, we got a decision. And the thing, Dan, about Himani that was really momentous is that it was a unanimous decision. It was 9-0, right? 7 concurring in the opinions, right? And in the majority, I think it was like 6 or so, and a couple other concurring opinions, and then Kagan and Alito concurring in the judgment, right? So what they essentially found was consistent with the fun remarks that some of the justices had been making at the oral argument in the case, right? that you can't impose a status-based ban against people simply because they use something that in many states is legal, that the president recently, through order, moved medically into Schedule 3. That is the subject of these rescheduling hearings that are coming up that we'll speak to. That, of course, we would have liked to have been at the table next week, but won't be. But needless to say, the Supreme Court noted the sea change in the views towards cannabis and the current role of cannabis as one that is akin to the way alcohol was used during the founding eras of the Republic. I think it's Justice Kagan who made that remark about the way that marijuana is like used today, the way alcohol was used in the past. But at the oral argument in the Hamani case, I was struck by some of the analogies by the justices. You had Neil Gorsuch asking questions about whether a person who had taken a cannabis gummy at night for the purpose of perhaps, getting to sleep better, was going to be within the ambit of the statute if they also happened to possess a firearm. Justice Sotomayor, New Yorker all the way, talked about whether people at a party on the weekends who consumed I think her phrase, I know it was, a stick of cannabis while not possessing a firearm could then go back home to where they did have a gun and be liable under the statute, even though they were not intoxicated or at any time when they were near the gun. And Justice Amy Coney Barrett had two interesting examples. One was the college student cramming for exams who uses his friend's Adderall, right, for purposes of studying, and maybe they possess a gun. Should they be barred from possessing a firearm because of that use of the illegal drug and an illegal use in that case of a prescription drug, right? And then the other example was the spouse and the Ambien, and like, what happens if you need to sleep and you take some of your spouse's Ambien and you don't have a prescription, but you have a firearm? Are you now within the ambit of that statute? And the government again and again and again, no matter what the circumstance, took the position that yes, 922G covered your conduct and you were criminal under the statute and you were one gummy bear away from being like imprisoned and felonized for the rest of your life. Right? So, not surprisingly, when the decision came down, that position was resoundingly rejected. The status-based ban on people in this case was rejected. But the case itself has like kind of a narrow application. It's not one that makes it legal to possess marijuana in all instances and a gun, right? Or substances in all instances and have a gun. The court points out that there may be some substances out there, not marijuana, for which there is in all instances linked to safety and some kind of a ban, but that wasn't before the court. They also noted that they're not making a rule that, or they're not, I should say, abrogating a statute and saying that, for example, actual drunkenness or intoxication is beyond prosecution. They're not saying that being a felon in possession of a gun was like beyond prosecution. They're not saying that a person, as was in the case of Rahimi, you may recall from a couple of years ago, who's actually subject to a judicial finding of dangerousness and who's been disarmed. They're not saying that that's unconstitutional either. So Hamani was a wonderful victory for people who consume cannabis on some level and have a firearm as well, and for hunting or target shooting or whatever purpose, are in possession of that gun, but are not actively intoxicated, as the court found to be really the linchpin of this kind of disarmament. So that's the opinion in short, and it was, I think, eminently fair. I think it would have been aberrant if it had gone the other way. I was pleased to see that it was a unanimous opinion. And if you think about it being, for example, the other way, there are greater implications. And we had pointed this out in our amicus brief. The last time there was a status-based ban was in like the 1760s when it was the French Indian War, and there was a status-based ban by the Anglican Church on Catholics possessing firearms because they were so dangerous to the crown, right? But if you were able to disarm marijuana users simply because they were marijuana users, the question is then who's next? Is it Democrats, independents, democratic socialists? Like, where do you start, right? Is it blacks? Is it whites? I mean, where does that end when you engage in a status-based ban? And so, as in many of the things that we're doing, We start out with marijuana as the premise. It expands to the common ground, but the decisions that are being rendered resonate well beyond the walls of marijuana legalization. I mean, they resonate far and wide about liberties that are way beyond this ostensible, right to consume cannabis as an adult, and frankly, as a non-medical patient. So I'm so psyched about Hamani. I have reason to believe we've got some other cool amicus stuff coming up. I'm looking forward to a potential challenge brought by Dan in Missouri about the state and their expungements, and he and I are going to continue that dialogue and hopefully bring it. And may that be the fifth in our chain of, positions that have been endorsed by courts. Rescheduling. I can shift to rescheduling. Rescheduling is an interesting one. On April 26th of 2026, the Attorney General issued an order indicating that medical cannabis pursuant to, I should say, within the confines of a state licensed medical regime, and also FDA approved medical cannabis formulations, of which there are like two or three, would immediately be moved to Schedule 3 of the Controlled Substances Act, pursuant to the Attorney General's authority to act under a statute that's named 811D1, 2, 3, and 4. For those of you like law nerds who really want to get into the weeds. But what Attorney General Blanche then did was he bifurcated this substance based upon the way people use it and said, we're now going to have a rulemaking hearing, one that had originally been scheduled for 2024, but then put on hold because of allegations in the way that the DEA was coaching and selecting certain interested participants and, kind of skewing the table and allowing some people to be heard, not others. So that was frozen for a while, but the hearing was then reinstated and is scheduled to start this coming Monday in 2 days on the 29th of June. And at this hearing, the second part of Todd Blanche's order is the question, can all cannabis, not just cannabis under a medical license or FDA formulation, all of it be moved into Schedule 3 of the Controlled Substances Act? And what was done was the administrator of the DEA received from various potentially interested persons a request to participate. NORML filed a request to participate in the rulemaking. We argued we were an interested person. We argued that although Schedule 1 was an improvement, I should say Schedule 3, an improvement upon Schedule 1, and that cannabis couldn't remain in Schedule 1, it wasn't an endpoint. We argued it was an incomplete fix. We argued there was still, concrete injuries that were being suffered by our members who are principally consumers of cannabis, and that would be suffered by them if they were required to abide by a Schedule 3 regime, which would involve either prescriptions and a pharmacist, or to the extent something is not governed by something called the Food, Drug, and Cosmetic Act, by, a pharmacist nonetheless absent the prescription, but still in a regulated medical mode. And we made our application that was ignored. I should say, first we were told no, right? We were not granted interested party status. The only ones that were 7 prohibitionist groups, including, for example, Smart Approaches to Marijuana, National Association of like alcohol and drug testing laboratories, a couple other individuals who were opposed to marijuana being moved from Schedule 1. But all the advocacy groups, NORML, MPP, all the individuals associated with them, any of the doctors groups, the medical groups, any of the people, including people the Hemp Alliance, right, that had been granted status previously to be heard, were denied. And NORML hadn't been granted it previously, but we were denied again on the theory that we weren't interested persons. We may be interesting, but we weren't interested within the ambit of the statute because we favored the shift from 1 to 3. And it didn't matter that that was imperfect to us. It didn't matter about our, concerns about what happens to adult use consumers who now are with a stroke of a wand going to be made patients. So I asked the administrator to reconsider on behalf of NORML, as counsel to NORML, his position, and that was declined. And it was declined as to every interested person that had sought reconsideration, and the hearing is now going to ensue on Monday. Interestingly enough, I also undertook to represent Marijuana Moment, as many of you know, is like a very independent journalist in the marijuana sphere, very well known, provides a lot of us our news in an effort to get live stream access for the hearing. Because in 2024, the administrator had gone out of their way to ask for live stream access in this matter of national importance and because of DEA's interest in transparency. This time around, a new administrator said there's no live stream, there's no overflow courtroom, you have to RSVP, we can't guarantee you a seat, none of that stuff. And in the interest of the same transparency, I imagine, I mean, transparent, it's like clear. In the same interest, allegedly, there would be a transcript provided at the end of the proceeding, a couple weeks after it started, that had been corrected. And so, I took the position, and Law 360 joined in with us, and a reporter, a cannabis reporter from the Times, and another news outlet joined in with us, asking that, and actually Representative Steve Cohen joined in with us yesterday, asking that this hearing be live streamed. And I initially filed our request with the administrative law judge. He responded obliquely by issuing a scheduling order barring communications with the tribunal by non-parties. So I then filed with the administrator again, asking, him to rule on the application to live stream. And last night, Dan, I got an email from the press office at DEA saying they weren't going to do that. And I responded, because a lot of this is you got to respond to get an answer, right? You can't just quit. You can't just lay down. I asked them if they would have the administrator, tell me that, and wondered whether he'd actually seen my communication, and was wondering whether they could indicate to us, as they have to under something called the Administrative Procedure Act, why they've changed their formerly stated position, right? You have to give a reason, right? You can't just do it. And so that's kind of in flux. I have no doubt about what happens. If I'm lucky enough to get a letter back from the administrator, I presume it'll be a denial. That leaves people in this ineluctably unattractive position of trying to either pursue a stay for whatever reason on a weekend before a hearing when there'll be a transcript and there is some media access, or, as I think we're going to do, let our discretion get the better part of our valor and just kind of NORML, for example, has an intern that we'll be sending into the court hopefully every day. They, I imagine, will have some kind of a line outside from 2 a.m, like it's the Brandy Melville sample sale or something, right? But we'll have our people there, and hopefully we'll be able to gain court access. So that's another interesting wrinkle, and another interesting position we've staked in is we've defended consumers, and I think that's very, very important, and their right to be consumers and not to be medicalized. And at the same time, we're defending the right of the public to see something of extraordinary importance that should be transparent, particularly when we have reason to see that the only entities that were selected to be heard are all these prohibitionist groups. And the only entity that's defending this proposed move into Schedule 3, imperfect as it is the DEA. And so it's been kind of like a busy and interesting week in pot. I'm proud of the positions NORML struck. I'm incredibly proud that we were on the front line of that and that we got out ahead of those issues. I love the work we're doing with our amicus committee, and we're going to continue to do it and do it and do it. I feel like we found this sweet vein of what we're doing right. We've got some really great lawyers like on our board, on our legal committee, in our midst. We've got people that want to join what we're doing, and we managed to rally them around our efforts. And it's extremely gratifying to say the least.
Joe, thank you very much. Could I mean you've touched on it, but can you predict? And this is off topic, but can you predict whether the Hamani decision is going to be extended to other substances? Is it limited to cannabis, or is that even clear?
It's not limited to cannabis right now. I mean, for example, you could be, I don't know if you could actually be an infrequent user of meth, but presuming you could be. You could theoretically be off the meth and, at the target range and you don't meet the statute. The court has invited Congress to build guardrails around that. Maybe DMT or some drug that causes you to dissociate from reality, even briefly, might be something that's a good disqualifier for you to have a gun. But that's for the legislature to determine. As it stands right now, Dan, I would argue if I was in one of these cases defending a person that there's no evidence of that actual dangerousness because that's what it is. Are they actively intoxicated? You may not like what they do. Maybe it's a moral issue. Maybe you're not into their substance, whatever. But the questions are they actually intoxicated, right? Actively intoxicated in a way that's dangerous. And one of the better parts of that oral argument, I thought, was at the beginning when the justices were talking about the founding fathers and their drinking habits, right? And it was noted that you could be a habitual drinker, excuse me, but not a habitual drunkard. That you can drink all the time, right? Like drinking Madison and his rye for breakfast, right? Or whatever. Franklin and Jefferson and the Lafitte's. But that didn't make you a habitual drunkard who should be disarmed, right? There had to be more of that. There had to be a greater finding than just you drink alcohol. And I mean, here's the thing with pot, particularly so today, right? The other side talks about high potency marijuana and psychosis and youth using marijuana, the emergency visits increasing and everything else. And they paint a picture of dangerousness in this upcoming hearing, right? And on some level, that does go to the question of whether someone should be disarmed because of their intoxication or their dangerousness, but it's not cannabis specific in the slightest. It seems to have a temporal limitation of intoxication. Most of the substances that we know people to use do have an endpoint, a terminus, right? You're not perpetually tripping. Maybe that's not a great example, but it kind of is a great example. And then there's other drugs we know, like you're probably always on crack or running around trying to get some crack, right? I imagine meth is the same way. These are some of the substances that are probably in the category of ones that you shouldn't be actively utilizing while possessing a gun, right? Things where all of your behavior is organized and controlled, like around getting the substance, you're controlled by it, I think are good candidates for there to be that exclusion. But I don't think others are. And I find it to be a fascinating line of cases culminating in this opinion. Good for us in many ways, right? And you see the court citing the rescheduling movement in favor of its decision, but I don't think the same works. Like, I don't think, for example, the Himani decision helps us so much with the Schedule 3 assessment, right? It's a little bit siloed. You could conceivably be so messed up on a Schedule 3 or 4 or even 5 drug that you should be disarmed. But it's not bad for us. It was a pretty good week for marijuana, I think, as to the court. And my fear with rescheduling coming up is for all the progress we've made, I mean, life is kind of like not linear. You take 2 steps forward, you take 1 step back, right? So saying music. And maybe this is what happens with this Schedule 3 hearing of ours. Maybe, and I'm pretty sure that after the final rulemaking dust has settled, whatever it is, and the appeals are done and all of that stuff is done, which could take a while, and we know what the rule really is. I would not be surprised in the slightest if NORML forthwith files some kind of another petition to remove marijuana from the schedules entirely. And I'm struck by this idea of you do not need to be a scheduled drug, frankly, to still be controlled within the ambit of the single convention. You don't need to do that. And if you take that, right, which is the ability to deschedule without deregulating, and then you take the forward thrust of this general consensus among, say, jurists in the know that marijuana is kind of like alcohol of the olden days, then you've got some like a pretty decent moving platform to improve upon our position. But I fear that where we are now is larger marijuana businesses were so interested in the 280E safe harbor, getting out from under that disentitlement with Schedule 1 and 2 drugs, that they wanted to do anything possible to secure Schedule 3. It's not clear to me that they put the consumer interest uber alles And there's an idea that, there's plenty of consumers who can now go out and get a prescription or a recommendation and get something they couldn't get otherwise. And they could well replace the void. But this rule, and particularly we'll have to see what happens with adult use. But if adult use is treated the same way as any other Schedule 3 drug, well, then every store that you and I know, Dan, in Missouri, it could be New York, it could be anywhere, all these mom and pops, smaller businesses, places that are actually dispensing the substance are, if you're reading the Code of Federal Regulations right, going to need a pharmacist, at least for the purpose of giving it, even if it's a non-prescribed substance that's outside of the control, as botanical weed is of the Federal Drug and Cosmetic Act. So botanicals, the only path I can think of to getting these botanicals, maybe not a prescription, but it's some special dispensation, quite literally, where the pharmacist is using a section of the Code of Federal Regulations that's available for schedules between 2 and 5, but like never used, right? So there has to be some kind of an ability to do that. And that's not going to favor all of these social and economic equity or legacy licensed people that are often operating on a shoestring and losing money anyway, right? They're probably not going to be able to do it. So we might see a consolidation of marijuana per se, right? In terms of the points of sale, how it's sold, what the legal market looks like before we get to our next stage of this battle, so to speak. And so one could say this is an end game of a sort, but this end game opens us up to the next chapter in the chess match, right? So
Absolutely.
it's really, really been an amazing study from beginning to end. But I also fear that a lot of us have had blinders on to what might happen in the event that we really get what we want, right? You really want Schedule 3? Well, didn't you want more than that? And why do we capitulate in the middle? Because the Office of Legal Counsel told you it should be a Schedule 3 drug, or like that was what someone told you we need for 280E. And how does that help our base, the consumer base, right? Does that really help the consumer of cannabis if now all of a sudden you need to even if without a prescription, you have to have something given to you by a pharmacist? Dan Vietz is going to have to go to some place and have a pharmacist check your ID, and they're going to know like how tall you are, what color your hair is, and when you're born to get a fucking, excuse me, a nugget of marijuana, right? And I mean, maybe in some places they do that anyway when you scan and you walk in, but the level of control for you to get the same thing overnight could change dramatically. And to me, that's not really a step forward. And I'm monitoring, I'm studying. I don't see a lot of state regulators getting out ahead of this. I don't see anyone getting out ahead. And the DEA could do this too. Everyone's invited to say, you're not going to need a prescription. It's going to be easy for you to get. Instead, what we see is Todd Blanche's memo talking about the single convention and how a substance in Schedule 1, which is where cannabis remains, is for scientific, medical use only, and has to be dispensed by, or at least prescribed by a doctor, right? You see everything that the government is putting out now, emphasizing medicine and science, and this notion of we bifurcated it and put some of it into Schedule 3 immediately. If you read his order, it says to avoid a disruption in patient access to medicine, right? It's not so we can figure out all you like party happy bohemians later in the day. That's not what's happening here. So again, how cool it is to be able to be out as like thought leaders in this field. And I've hoped for so long I'm wrong in the stuff I'm saying, but the more and more that we see this unspooling of things, and particularly with the way they selected interesting parties to do nothing but assert their position against DEA, I have greater and greater fears. Because I mean, imagine, Dan, the DEA is going to cross-examine all the prohibitionists, right? It's them and their 2 hours of whatever testimony, and then the seven and their 2 hours times seven, and all the cross-examination time. And we're relying upon the DEA to be the at the vanguard of supporting this rule for us. And you and I, as criminal lawyers, probably have a hard time getting a grip on the concept of them somehow aiding this marijuana ecosystem that we've come to know. So I do look forward to being hopefully proven wrong.
Hmm. Well, Joe, the Trump administration seems to have, to put it kindly, an inconsistent approach toward marijuana-related issues, and they were adamantly opposed to our position on the Hamani case, and yet some reformers want to read into the rescheduling of state legal medical marijuana that somehow Trump is a champion of marijuana law reform. I don't think he has a consistent or even a well thought out position on cannabis. But what I think I've seen in the last couple of days are stories saying that now the Trump administration, which promoted the ban on hemp derived products just a few months ago, is now calling for that to be at least modified, if not repealed. I mean, they seem to be all over the map.
So this is fascinating to me, and I'm not the genesis of these hemp bans, right?
Mhm.
Was a financial impasse in October of 2025, right? The government was going to be shut down. And so Congress came on back, and I must say I should know it better, but there was a lot of blowback, GOP blowback after the Farm Bill, right? The Agricultural Improvement Act of 2018. And I've said it before, it's one of the most ironic things to me in Mitch McConnell's, tenure as a congressperson is passing this Agricultural Improvement Act, and I guess thinking we're going to get better rope or sails or something or shirts. Instead, everyone got intoxicating cannabinoids because what the act did was take hemp definitionally out of the Controlled Substances Act, and hemp was defined as cannabis sativa L, plant from that genus, having a tetrahydrocannabinol delta 9 level of under 0.3% dry weight, right? It said nothing about Delta 8, Delta 10, things that were synthetically isomerized, other kinds of cannabinoids that were derived from hemp. Nothing about that, right? And moreover, you were then in a position to extract Delta 9 from hemp concentrated, put it into cannabis products, invert it throughout the country. And I'd spoken in Key West about inversion, right? Inversion into different states' streams of commerce. And many of these products were even hemp-derived THC Delta 9, cheaply made under some kind of the Agricultural Improvement Act of 2018. But in a long-named appropriations bill in November of 2025, there was a one-year sunset given to these kinds of cannabinoids. And there was only going to be a market in hemp products that would have been defined as having no more than 0.4 milligrams of THC Delta 9 per unit serving or whatever it was. And virtually every, like 95% of the hemp market would have been out of business, intoxicating hemp beverages. These things you get in Wisconsin. Had a great seltzer in Wisconsin. You can't get weed in Wisconsin, but you get a like hemp-derived seltzer, or the gas stations throughout the country, right? You can get these things. It were places where cannabis was illegal. Those were important cannabis products for people in jurisdictions where it was really punitive, really criminal for you to have marijuana, right? Those would have been taken away and gone. But not surprisingly, if you really think about it, Donald Trump with Trump RX and his interest in CBD for at least older people, perhaps even covered by Medicare or Medicaid, and the notion of pharmaceuticalizing marijuana away from hippies and people who bear this traditional weed stigma, the habitual drunkards with the low IQ who are akin to the mentally unstable, right? The other side, the demonic face that we get called by the Justice Department, right? But he's able to, on a certain level, control access, right? And that's what I'm saying about adult use is there's a way to shut this down and to systematize it and to put pharmaceutical controls on it that put a lot of these people who are benefiting from their prior involvement in, say, the legacy market even out of business, right? So the last week, the White House sent a letter to Congress urging them to not have this window, this sunset window on the cannabinoids. And I have every reason to believe that somehow Congress will void that out. I really, if I had to bet, on Kalshi or whatever the heck it is, these poly spaces, right? I'd bet in favor of the plant. And for those of you who are out there, like if you always bet in favor of the plant, you're going to come out ahead, right? And by that I mean I don't mean betting in favor of the people who are selling it on the stock exchange, right? I mean betting in favor of the plant itself. But yeah, it'll be very interesting to see what Congress does with that. And I wouldn't be surprised if it's more part of the omelet, Dan. There's this the omelet roll up into the controlled industry.
Well, I like that analogy. I like omelets. Joe, would you spend a few of your remaining minutes here talking about NORML, talking about why it's still important that NORML be working on behalf of cannabis consumers and why people should give support, and I mean financial support to NORML.
Yeah, absolutely. There's and I have my own views on this, obviously, which are different maybe than other people. And we can all have different reasons for supporting organizations that we care about, right? And I'm also not like a one-track guy. I care about like freedom and liberty and rights and people and things that I think are good. I try to support groups and organizations that I think are doing positive things. And by that, I mean human beings in our country, for rights, for our Constitution. And normal has been something that since I was a very young lawyer, I wanted to be involved in. And I remember when I did my first lecture in 1998 in Key West, right? So that's like my very first one on federal sentencing guidelines. I can't tell you how happy, how amazed I was to be in the room with like you, right? And other people. It's the truth. And because we never know, I had some lawyers say something to me about me, and I never knew I had this effect upon them, right? But we never know, like, who's watching and being impacted by what we're doing. And I feel like I saw some extraordinary role models really committed to marijuana reform at a time when there were far fewer people who were into legalizing marijuana, right? And it was, excuse me, like working through stigma and criminalization and facing mandatory minimums for our clients. And the bulk of the legal committee were criminal defense lawyers. And we would again and again and again come to face this injustice. And we've done quite a bit to try to fight against it, I my last federal marijuana client now has a cannabis license in the state of New York, and I got him off supervised release early so they could pursue that. Like
Great.
that's a pretty cool one, right? There's so much expungement work that we've been doing now, but normal was the intellectual like nursery for all of this, right? This was the place where we could speak to our peers and run these ideas off people and have these concepts and maybe find some lawyers to make it work, right? I've made great friends through my relationship with Normal while trying to do the right thing in the cannabis space. And I remember when pot wasn't legal in New York and I was a National Legal Committee member, I'd get all these phone calls, like ten phone calls a week from some person that got busted smoking a doobie. And I was like, I knew what to say to them. And I was never trying to pitch them to be like their lawyer in the Doobie case, right? I was just trying to help them win a dismissal or help guide them somehow because I thought that was the greater good. And I appreciated that training ground, like a dojo, like a school where you could get better and better and better. And I appreciate now, maybe more than ever, right, Dan, the things that we've been doing and the work we've been doing, and particularly in the past couple of years, we're surviving, we're intellectually thriving. Sometimes it's financially difficult. It seems like a lot of people support our efforts, but supporting our efforts, you know, emotionally is sometimes different than keeping a burger on the table. But that challenge also has been extraordinarily sweet for me, as you know, and you've even watched me over the past couple of years rise to this normal occasion. It's a great time for us to get out as an advocacy group and be involved, and it's a great time for us to be at the lead of that and to try to help shape not only public opinion but policy along the way. So my final pitch is if you haven't already, donate money to Normal. It's a really amazing organization. We do it also, and we stand by, the things we do. And if you've got a special skill or a talent or anything like that that you want to offer, let us know. And our door's always open and our phones are always on. So far.
Thank you, Joe. Thank you very much.
Thank you.
You bet. Our organization, to some degree, I think, has been a victim of our success.
Yep.
We have helped to first decriminalize and then to legalize medical marijuana in 40 states, more or less, and then to legalize non-medical adult use in 24 states at this point. A lot of people think that the battle's won, the war is won, that we don't really need NORML any longer. And that is not true. There will always be a role for advocates for the interests of cannabis consumers, and that's exactly what NORML is. Thank you again, Joe, very much. I look forward to seeing you in Key West and perhaps sooner on Zoom.
See you soon. Thank you, Dan, for having me. Thank you very much, everybody. Have a great day. Take care.
Sure. Folks, our next guests, and I think we're going to have two guests coming up, are both with the Division of Cannabis Regulation, a part of the Missouri Department of Health and Senior Services, which was charged under Article 14 with implementing and administering the implementation of legalization. First medical back in 2018, and then non-medical adult use in 2022. One of the things, yes, here's our second guest right now. One of the things that we did in the process of writing Article 14, Section 2, was to mandate the establishment of a chief equity officer for the state of Missouri in regard to administration of the marijuana legalization program. And Leslie Turek has recently taken that position. She is the CEO, so to speak, of cannabis regulation in Missouri. We also are pleased and privileged to have with us this afternoon Dr. Rika Yu, also with the Division of Cannabis Regulation for Missouri, and the Director of Policy for that entity. So I want to welcome both of you this afternoon. I want to tell you that you're not going to be rushed, that we had a couple of cancellations of some of the legislators that were going to speak after you. So I want you to take your time, go into as much detail as you wish and as you're willing to do in your presentations. And either of you are welcome to go first. I don't have an order in mind, but I guess Dr. Yu is listed first on the agenda. So let's go with Dr. Yu, please. Would you introduce yourself?
Hi, everyone. My name is Rika Yu. I am the Policy Director with the Division of Cannabis Regulation. I guess I've been with DCR now for a little over a year, but I'm here to talk about some updates regarding the research license rules, as well as some updates for the reference lab. And I will let Leslie talk about micro businesses when it is her turn. I will say my updates may be a little short, so even though we're not rushed, I'm not sure I can take all the time in the world. For reference lab updates, I will admit I will be giving these updates as less of an expert because our product integrity bureau manager is really the guy who knows all about our state public health lab, Ryan Bernard, but I will be giving updates on his behalf. So the information I have for this is that currently the state public health lab is operating 4 out of the 8 methods required and that are listed in testing rule. So these methods include the cannabinoid profile excluding terpenes, microbial screening, water activity, and moisture content. Methods that are still in development include chemical residue, heavy metals, residual solvents, and foreign matter. And then for the routine sampling program, the State Public Health Lab and DCR has just started their 3rd round of sampling, and more than 220 samples have been collected and tested since the start of the sampling program. And I think a couple months ago, we kind of saw how important this routine sampling program is because we actually found in one test the presence of aspergillus, which led to public recall, kind of emphasizing the importance of having this check on our end. And then the State Public Health Lab has also supported DCR's interlab comparisons and they are planning the logistics for receiving, preparing, and distributing samples. The first round of interlab comparisons included 2 of the 10 samples planned per year, and the State Public Health Lab has also participated in the blind testing of those samples. Regarding research licenses, so research licenses just finished their formal public comment period, May 31st. And so we are currently looking at those comments, incorporating changes and responses to those comments before we file these rules as final rule with JCAR and the Secretary of State. We don't know the exact date we'll be filing yet, but those rules will become effective before the end of the year. But we will likely be opening up the applications for the license itself sometimes next year, as we still need a little bit of time to implement all our systems needs and the support for the program. As for the rule itself, if you hadn't had a chance to read it, it essentially establishes a new license type, which is to research marijuana. The rule provides guidelines for applying for a license. And then once you receive a license, it provides guidelines for applying for study approval for each study that you want to perform under the license, as well as different requirements for studies that include animals, humans, and or just including cultivation. And we don't have any license limit for this research license. The Constitution doesn't set any limit for this. It just establishes that we have the ability to create this license type, and the license will be open to existing licensees or any other entities as long as they meet the requirements in Rule 4 licensure.
Can you tell us what those requirements are?
Well, most of them are pretty basic and similar to the existing licensee requirements. So related to DFOs, requirement to include all the business info necessary. On the more specific side, it applies a little bit more to the studies where even after licensure, for example, if you are doing an animal subject study or a human subject study, you are required to have a principal investigator or a lead investigator that has 5 years of experience in that area. So some of the more specific requirements are to ensure that the research group has the necessary experience so that any animals or humans involved in the study aren't put at risk.
Okay, very good. So it sounds like you're anticipating that applicants for research licenses could include not only universities and professors, but businesses or even individuals. Is that correct?
Correct. Yes, that's correct.
And moving back for a moment to some of your earlier comments, you used the term water activity. What is meant by that? What is water activity?
Oh, I know that there is a bit of a scientific difference between water activity and moisture content, but I'm not quite sure that exact scientific difference, to be frank. I'm sorry.
Similar to water content then of plants, I presume.
I think it's similar, but I believe the way they are measured it uses a different unit of measurement, I believe.
Okay. Okay. The testing, I believe you said there have been 220 tests done now on products taken from store shelves, is my understanding. Can you tell us, I mean, you mentioned finding aspergillus in a sample and recalling that product, which is a form of mold, is that correct?
Correct.
And have there been any other findings of any contaminants of concern?
I will be honest, I have not been involved with this process in my position, but my understanding is not. I think if there was any finding of concern, it would also lead to further investigation to check. And then if if that finding is confirmed, then it would lead to a recall, which would be publicly announced.
So, I mean, that is part of the what we've called purity and potency testing. Is just the short soundbite term we've used. In terms of potency testing, has the reference lab found that the licensed testing laboratories are accurately reflecting potency? Is there no exaggeration of potency in their testing?
That one I also am unsure. I'm so sorry. I don't have that information. But I think that would be coming, I believe, from, I think that's something we might be comparing or testing accuracy for potentially in the interlab comparison, but I'm also not 100% sure for how the labs side of our work is testing that. I apologize.
Okay, well, that's fine. That's the right answer if you don't know. One of our concerns, and we've expressed this to some of your predecessors, is that a year or so ago, the department recalibrated, I guess, its tolerance level for a substance known as vitamin E acetate in cannabis. And back in the early 2000s, actually before COVID became the dominant news story, there was a great deal of news coverage about the fact that people were being hospitalized and in some cases were dying because they were using vaporizers that included in the substance being vaporized vitamin E acetate, which was apparently being placed there primarily by illegal manufacturers because it increased the viscosity, the appearance, it improved the appearance and the marketability of the product. And we were very concerned about increasing the tolerance for vitamin E acetate, in fact, by 25 times what it had been previously, when I'm no chemist, but my understanding is that there's no vitamin E acetate present in organic cannabis. Are you familiar at all with the policy of the department on vitamin E acetate?
Yes, so I'm aware of the change, but my understanding is that we don't have any additional comments on the reasoning or the why for why we made that change.
What were the previous comments? I don't recall what the previous comments were.
I'm also not 100% sure on that as well.
Okay.
I will admit this happened before I started, I believe.
Sure, it did. So you're not responsible for it, but it is a matter of reasonable concern, I think. I mean, people are dying from this substance. We are concerned, and we will continue to be concerned about that. You've mentioned that there will be an option for human test subjects to be involved in research, and that I think is what's generally called clinical research. And I want to tell you that we're very happy that is an option. One of the arguments we used to hear all the time from the prohibitionist side was that marijuana needs to remain illegal because we just don't have enough research on marijuana. We would say, well, we've got 30,000 plus studies on marijuana, more than we do on most pharmaceuticals. And they would say, oh, yeah, but those aren't clinical studies. Well, it's very important, I think, not only just to answer that argument, but for the sake of having useful and realistic research, that there be the option for clinical studies. So I'm very pleased. Now, will those who obtain a research license from the state of Missouri, from DCR, will they also be required to obtain any sort of national or federal license or permissions?
They will not be required to. So under these research rules, only our DCR research license will be required.
Mhm. Okay, well, that's exciting. That's I think very positive, very good to hear. I want to mention again to our viewers that if you want to submit questions for any of our guests, any of our speakers, you should be able to do that on the chat option at the bottom of the page, or through YouTube. And please don't hesitate to do that. We've had a lot of comments, but not really any questions. so far as I can tell, from our audience on this particular topic, or on previous ones for that matter. But please don't hesitate to send in any questions, or for that matter, any comments that you wish to share with us. Um, let's see here. The reference lab and the option to do research are certainly very important. Are there any other policy related matters that you're working on currently?
We recently posted some draft rule amendments to parts of our rule regarding ownership and employment and general facility operations. So we are currently responding to those informal comments. And once we make all the changes in response to those, that will then begin the formal rulemaking process, which should be happening sometime in the future soon.
Okay. And is this in regard to what's been called predatory licensing applications?
No, so that those changes or that language was probably more associated with the amendments we made to the microbusiness rules, which were finalized and in effect May 30th. We had proposed additional rule amendments to 070 and 100 to help clarify some ownership requirements.
Would you tell folks where they can find both the existing and the proposed rules?
Yeah, so I don't think the draft rule is available anymore. So it was only open for a couple weeks for comment. But the current version of those rules can be found at the Secretary of State's website. So our rule number is 19 CSR 100-1. But when we do file these rule amendments in the formal rulemaking process, we will put out a press release sharing the information where they can find the proposed rule amendments and how they will be able to provide formal public comments to those.
Okay. All right. Well, very good. We certainly appreciate you being with us. Is there anything else you'd like to cover or touch on?
I'm trying to think. I'm sure you've had quite a few people speaking about rescheduling in the DEA hearing. I will just say we did put out a communication to licensees early on, trying to answer what we could. Unfortunately, we don't have additional information, and I think we are in the same boat as everyone else, where we are trying to stay on top of everything, trying to keep up with any new guidance to see if that will bring any clarity with the rescheduling order and the upcoming rulemaking process.
Mm-hmm, mm-hmm. I probably should have opened with this, but would you mind telling folks a little bit about your background and your education and how you came to this position?
Yeah, so I think I think people might be a little bit surprised about my background, but I actually was trained as a biologist, and so I went to grad school for biology studying pollination, and then
Where did you go?
because I was more interested in the policy side and trying to apply research in that sense, I actually started a fellowship in Jefferson City where I worked with legislators to provide nonpartisan research, and then ended up here at Cannabis at DCR, mainly because I was interested in being in a position where I could help support evidence-based policy.
Well, good. We certainly support evidence-based policy ourselves. Are you from Missouri?
I'm actually not. I'm from California,
What
but
part?
somehow found my way into Missouri.
Oh, yeah, a lot of people do. What part of California?
Southern California, Orange County.
Disneyland. Love it. So,
Yeah.
where did you go to school?
I went to school in Boston, and then I ended up at UMSL, University of Missouri St. Louis, for grad school, which is kind of how I ended up staying here.
That's great. That's great. I know that some of the universities here in Missouri have implemented at least some certificate programs, if not some degree programs. Are you familiar with any of those that are being offered currently?
For cannabis?
Yes.
I believe there is a program, I believe Truman might have a degree program for cannabis. And I think there are WashU St. Louis might have a certificate program. And I think potentially some community colleges around the Kansas City and or Springfield area also may have certificate programs. But I think Truman is the only one I'm aware of where there is what I think there is a degree program for. I'm not quite sure if it's cannabis management or something more specific.
I've heard that there were programs at UMSL and also at Northwest State University in Maryville. Are you familiar with anything like that?
I'm not familiar with anything like that. It's potentially that is newer. But when I was there, at least I didn't hear anything about that.
Okay then. Well, once again, thank you very much. If you could remain available, we might have some questions for you later.
Definitely.
Leslie, would you please give us your presentation, and in particular, of course, in regard to the micro licensing program?
Absolutely. Thank you for having me today. I appreciate it. For those people that don't know me, my name is Leslie Turek. I've been with DCR for about 4 years now. I started off in compliance and then moved my way over to the current position that I have. I've been doing the CEO position for almost 3 years now. So I've been with DCR since the beginning of the microbusiness program. I just worked in compliance the first year that it came around. So I'm pretty familiar with it. For those people that don't know about the microbusiness program, it was established when adult use cannabis was legalized. It's part of Article 14 of the Missouri Constitution. And within Article 14, it established this, some call it a social equity program, some call it a small business opportunity. It's kind of both lumped into one. So there are some really specific requirements within Article 14 regarding the Missouri microbusiness cannabis program. For example, I can't highlight all of them, but for example, microbusiness licensees operate their facilities separately from the rest of the market, the rest of the industry in Missouri. So business transactions happen within the microbusiness facilities themselves. So that means licensees can only sell marijuana to each other. You won't find microbusiness products in the larger comprehensive market. They're only going to be found in microbusiness dispensaries. Their microbusiness licenses are handed out by congressional districts. And we use the 8 congressional districts that were effective December of 2018. So all of the redistricting and stuff that's happening does not affect the congressional districts where we issue licenses at this point. We also issue licenses by an anonymous lottery drawing. I know some people are kind of don't believe me on that, but I swear it's true. We use the Missouri Lottery Commission to help us pull those licenses when we're ready. And then DCR is required to issue a minimum number of licenses by Constitution. We are expected to issue at least 144 licenses. And it asks us to do that within 3 rounds of licensing. We've already done 2 rounds, so we are currently planning and working towards that 3rd round of licensing. We use Article 14, DCR did, to establish the rules and regulations that are set forth in the Code of State Regulations, which again, I think Rika said that earlier. It's in 19 CSR 100-1. The whole of Missouri's cannabis program is within that CSR. Specifically, there are some areas that also dictate what we use for licensing and regulations with the microbusiness program. Licenses. There are 2 types of licenses that are available to this program. There's a wholesale license and there's a dispensary license. Wholesale license is unique to the microbusiness program because it focuses on both cultivation and manufacturing together. These licensees are able to choose an activity. They can just cultivate, they can just grow, they can just manufacture, or they can do both of those things together. There is a plant count limit that is established in Article 14 of the Missouri Constitution for wholesalers. If they choose to go cultivate, they may cultivate 250 flowering plants at any one time. And I like to stress that it's 250 flowering plants at any one time. And that's not something we can change. I get asked that a lot, to change that plant count, but since it's established in Constitution, that is where we stand with it. And then microbusiness dispensaries are exactly what everybody assumes that they are. They sell to consumers, qualifying patients, or primary caregivers. They will only be selling microbusiness marijuana products or infused products. They are able to make their own pre-rolls if they like and sell those, but those are not infused pre-rolls. So a lot of the questions I've been getting, I've been going on a state tour lately to educate as many people as I can about this program. And I get a lot of questions about a wide variety of topics. I'm kind of in wrapping up the end of my June. I have one more webinar to go. That's on Monday. And then I've kind of like done as much education as I can put out there for everyone. But I'm always happy to answer more questions if necessary. So a lot of people have been asking me, what is the purpose of a microbusiness program? Why was this even established? So we've really spent some time at DCR really trying to make that as specific as possible, so that, and as in plain language as possible, for everyone to really understand. The purpose of this microbusiness program is to provide a path to facility ownership for eligible individuals who would not otherwise have that opportunity. So there's a couple of really key things in that purpose that I try to tell everybody to keep in mind. Number one, it's the facility ownership. We stress a lot about owning and operating a microbusiness license, and what does that look like? The second part of that is the eligibility section. That you do have to meet an eligibility criteria in order to qualify for the program. So we have been through 2 rounds of licensing, and DCR did discover that there were some issues, lots of different reasons, but we saw some recurring ones. And because of that, we took some time, we took a step away after round 2 and really looked at our rules and really thought about how can we clarify these rules so that they really focus that attention back on the purpose of the program. So we were lucky enough to have Rika at that point at DCR, and we spent a lot of time in discussions about what needs to be clarified. So one of the things we looked at heavily was the term owned and operated. That has always been a part of the microbusiness program. That's never changed. But the expectation is that every microbusiness license is to be majority owned and operated by an eligible individual. That means that the individuals who meet those eligibility criteria, who apply and then are issued a license, must own more than 50%. So that means financial interest and voting interest in the license. And they must also have more than 50% of the power to basically make decisions for the license. That means ordering the management, the managers, the policies of the license for the life of the license. Again, we spent that time to really clarify and focus that attention back on the purpose of our program. We also added a few other things when we did rule revision, and that's why it's taken us so long to get to this point. We wanted to make sure that the program was really focused on that purpose. So we looked at requiring designated contact, for example. That's the individual that's connected to the license that has the communication avenue open to DCR. This is who DCR speaks with about whatever is needed. That designated contact now needs to be the eligible applicant So whoever is claiming eligibility in the application needs to also be listed as the designated contact. We discovered in past rounds when we were doing some verification processes that sometimes it was really difficult to get information from that eligible applicant owner if there was a third party involved. And we did have a few denials based on that. There was no communication happening between a third party designated contact and the actual applicant. So we really needed to make sure that we could speak directly to that applicant. We also focused some attention on agreements. So there were some issues with agreements that we saw in the verification process. And without being too specific, agreements cannot automatically take ownership or operating control away from the applicant. And then if it progresses to issuing a license, it cannot take that away from the eligible owner of the license. So we're really specific about agreements. That doesn't mean that people can't have agreements. You certainly can have agreements for consulting or for management or for investment purposes, but we really do take the time to examine those agreements. We have a great legal team that really looks at those and really tries to determine, is that 50% or more ownership going to be taken away from the licensee, or the ability to be able to operate the license, is that going to be taken away from the licensee, from that eligible individual? Because that's what the purpose of the program is to give those people the opportunity to be able to have a facility available to them. And then we also added some training. This was kind of my big push. I really wanted some training involved. Both pre-application as well as post-licensure training is now required. The pre-application training is important, I think, because the more educated you are, the better. I really want people to know what it means to own and operate a cannabis license. Cannabis is a highly regulated business. And it can be daunting at times for some people. I've talked to far too many current licensees who've said, I had no idea just how much was involved in owning and operating a license, just from different aspects, just from the financial standpoint, just from the compliance standpoint. So the pre-application training gives them a good glimpse of some of the requirements that they're going to have to be able to accomplish if they receive a license. That pre-application training is already available on our website. That's cannabis.mo.gov. So people can take that right now if they're really thinking about wanting to apply to the program. It's 3 short videos. It's me talking in 3 short videos. And then there's like a little quiz at the end of it. So that is a requirement before application. And there is a confirmation code that you actually put into the application. So speaking of application, our application window will be open in July. They just recently announced that. So it will open for 2 full weeks, starting July 13th. And that's through the 27th, the end of the day on the 27th. And it will only be open for those 2 weeks. That's the only time someone can put in an application for the microbusiness program. It's very exciting. It's coming up very fast, but we're getting ourselves ready for that. And then just so that you kind of know, eligibility is a huge part of the program. There are 9 different criteria. Some of them are kind of lumped together, but there are 9 different criteria that are available for eligibility. And applicants just need to meet one of those criteria. They don't have to meet more than one. If they do meet more than one and they want to put them all into the application, that's fine. We will verify all of those if they like us to, but just meeting one is really important. So I don't necessarily have to go through all the eligibility criteria, but it's everything from net worth and income. There's some very specific standards with that. There's service-connected disability. So I have several veterans that are now licensees, and that's how they qualified, was through their disability, through the United States Department of Veteran Affairs. So they have disability award from them. There's also one concerning having a nonviolent marijuana offense. There's one just for the applicant, and then there's one for a parent, guardian, or spouse. That's very specific. Nonviolent is very specific on that one, but it's the arrest, prosecution, or conviction that's prior to December 2021. Those cannot include provision to a minor or driving under the influence. So those are two stipulations with that. We also have some residency-based criteria that someone could be eligible through. It concerns poverty levels. It concerns unemployment rates. It can concern historic marijuana incarceration rates. There's one about unaccredited school districts. So those are all residency-based, and all of that information is available, again, on the DCR website. There's information there, as well as the documentation required to prove that you're eligible, because that is part of it. Yes, you can claim one of the eligibility criteria, but you also have to provide a lot of documentation in order to prove that you are eligible for the program. Let's see what else. I just want everyone to know that there is an application. It's not a difficult application. I think there is a misunderstanding out there in the public that this is such a hard application. You can't possibly do this on your own. You can. We provide lots of resources on our website. The application, when you look at it, is very simple to follow. There are certain fields that are required, but then there are also some pro tips or some little information guides throughout the application that someone can just click on and read exactly what needs to be put into that field. There is a lot of documentation required. So I think I always tell everybody during my education presentations that one of the key things is to organize yourself. We have an application checklist, and we also have an eligibility checklist. Those are both available on our website. And using that to kind of get yourself organized, understanding what kind of documentation you need is a really great way to get started. Now, that's me telling people to do that, and I am probably one of the least organized people in the world. I have papers all over the place, but it's worth it to take that time to organize yourself and to be ready to submit the documentation that's required. So we do require things like you have to show your ownership in a visual sense. Again, those are not things that you necessarily have to have someone formally make on a computer. You can just draw it, that's fine. You have to have a blueprint of your proposed facility. And I've had some people say, how would I know? How would I know what my facility is going to look like? Well, imagine if you could have any facility that you could want, what would it look like? Think practically, but there are some very specific requirements that are listed on the application of what you need to have on those blueprints. That's really important. We also tell people that having a location, we understand at DCR that no one would ever get into a situation where they would go ahead and lease or buy a property before they ever have a license. So this is a proposed location. And this proposed location would need to be compliant with all DCR rules. Those are some really specific things, but they're pretty easy to find in the CSR. They're also listed on our website. So there's ways that everyone can really understand. The other thing I really want to point out is that we are available at DCR to answer questions. We have a general email box, inbox that we check daily, several times daily, that I'm encouraging people to go ahead and email that with questions. That email address is cannabisinfo@health.mo.gov, and we respond very quickly. There's also a toll-free number listed on our website, and people can call. That's open Monday through Friday, 9 a.m. to 4 p.m. And the staff members that answer those phone calls are very knowledgeable about the microbusiness program, so they're able to answer those questions very easily. And if they don't know an answer to something, they will take your number, they will find the individual who needs to call you back, or they will get the information and call you back to give you some more information about that. So the lottery selection probably will not happen until September. We do have a lot of processes that we have to do internally once we receive all of those applications. I don't know how many applications we'll get. I'm hoping a lot. My goal is 10,000. I don't think we're going to get 10,000, but who knows? You never know. So I think in the last round, we had about 2,500. So that's a lot for our staff to have to go through and verify. But we do have certain things that we have to check before it can ever move on to the lottery. We have to verify that no one that's applying in this program is also an owner already of a medical or comprehensive license. We also have to check that an individual is only listed on one application. So your name cannot appear on another application. It's one at a time. And then we also have to verify that fees have been paid before anything goes to lottery. Once we go to lottery, we choose then our top drawn. So we choose, in each round, there's always 4 wholesale licenses and 2 dispensary licenses per congressional district. In this third round, because of the previous revocations that we've had, we are going to fill all the rest of the holes. So I was just looking at this on Thursday before I left the office. I believe there's going to be 80 total licenses, at least 77, but I think we're at 80 right now to fill all the rest of the holes in the licensing. And I know I've had people ask me, well, how many for each congressional district, and which ones will be more wholesale or more dispensary? I don't have that information right now, but I will tell you every single congressional district needs additional licenses beyond the 4 wholesale and 2 dispensary. They all need additional licenses. So yeah, and then after it goes to lottery and we pull the top drawn, excuse me, Missouri Lottery Commission pulls the top drawn, then that's when we start our processes with reviewing for application requirements, that they meet compliance rules. And that's also the time when we will start fingerprinting, requesting fingerprints from owners. So that's not a new process in DCR. It's one that was put on hold for a little bit, and now we've started that up again. Specifically in rule, it says that all applicants have to be fingerprinted. We've actually done a variance on that rule. We just feel like because fingerprinting does cost money, there's no reason to have everybody fingerprinted. We can actually have just the owners of the top drawn from the lottery system actually be fingerprinted. So with fingerprinting, it is a state and federal background check, and we are looking for disqualifying felony offenses. So owners may not have a disqualifying felony offense. Now, with that being said, everyone's probably going to start asking, hey, what is a disqualifying felony offense? Like, which ones are they? I am not an attorney. I'm the first one to say that. I do not give legal advice. I don't know. That's just me being honest. It is in rule, it states that no owner can have a violation or conviction or guilty plea to state or federal law that is or would have been a felony under Missouri law. So if you want more information about that, it does talk about that in Article 14 of the Missouri Constitution. We do have additional information on our website. There are some exceptions to that, and those are more specifically on the website that you can look at. My best advice, what I would do, I talk to an attorney. If you're not sure, if you're really like, I have no idea if this qualifies or not, I would seek out legal advice and have someone evaluate that for you. So we don't ask anyone to be fingerprinted until we request those fingerprints, because that costs money. So we're not expecting anybody to go out and get fingerprinted right now. So that will be part of the process after the lottery draw. Once we finish all of our verification processes, which it does take some time, only then will licenses be issued. So I can't give you an exact date of when those licenses will be issued. My goal, DCR's goal, everybody that's behind me, our goal is licenses will be issued before the end of 2026. So those licenses will be out and be ready to start working towards commencement to be part of the microbusiness market. And then I have a lot of questions about refunds. What if I don't get pulled for the lottery? What if I don't get a license? There is an application fee that goes with the application. And I always get asked that too, like, how much is it? I think right now, unfortunately, because we live in the age of inflation, it has gone up. So it's a little over $1,600, which I agree. That's money. That's quite a bit of money. That is able to be refunded if you do not get chosen for a license. There are some specific things that you have to meet. Like, for example, you had to have been eligible. You had to have met that eligibility criteria for the program. There can't be any future or current legal actions that are happening due to the denial of the application. But there are refunds available. That application, when it's time for that, will be available on our website, and we will certainly put out an announcement about that. I think that's about it. I don't know what else. I'm happy to talk about anything else. I have such a huge presentation from before, but I didn't want to talk too much because that's what I do normally. I seem like I talk a lot, so.
No, we appreciate it, and thank you for talking.
Absolutely.
And you don't have your slide presentation with you, do you? I mean,
I actually do.
well, I had assumed, I guess, that you might want to use those slides, and I think we could screen share and allow you to put those slides up, but you may have already covered most of what's
I
in.
think I covered most of it.
Okay, well, good. Well, then let me point out, as an attorney, that one possibility, if people do have felonies which are found to be disqualifying, that they could seek an expungement. Now, not every felony is expungible under Missouri law, but many of them are. And so that's another a reason to contact an attorney if you think you may have a felony that would disqualify you. It may be that felony can be expunged. Also, my recollection, and I don't want anyone to rely on this without checking further, but my recollection is that even the disqualifying felonies, I think after 5 years would no longer prevent you from being held eligible. But again, I don't have that text in front of me. I would need to refer to it, but I want to encourage people not to be discouraged if they do have a past felony conviction or even an SIS probation, which is someone pleading guilty but not technically having been convicted. One question I have is about the actual literal physical lottery process. How is the lottery conducted? I know it's done by the Missouri Lottery Program, but do you know how they do it?
So we, first of all, once we have all of our applications, we sort them by congressional district, and then we sort them by license types. DCR actually assigns the anonymous unique identifiers. We don't see any names attached to those. And then that's what's physically taken over to the Lottery Commission. And so I will travel with the information over to the Lottery Commission. I sit in a separate room. They go and do their thing, and then they give us the information after they've pulled those. Then we go back to our office and we match up the unique identifiers with names. And that whole listing, the lottery listing, is then published on the DCR website.
Do you know if the actual choosing of the winners is done electronically?
Yes, it's done electronically.
Okay, so we rely on the computers to be random and objective.
Yes, we do. Absolutely.
Okay. We do have a question that I want to relay to both of you, Dr. Yu, and that is a question from Ryan Regal, who says after November 12, when all cannabinoids will be subject to Article 14, in other words, under the bill passed by the legislature in regard to hemp-derived products, I think is the reference here, will the licensee have to grow his or her own CBD, or will they be able to buy CBD from out of state? That's kind of a technical question. Certainly one I have not even considered previously, but do either of you have any thoughts on that point?
I think my answer will have to be I'm not sure. I think that would require a bit of, ideally, some guidance from some maybe national guidance on how the new hemp definition is going to be interpreted in
Mhm.
practice.
Mhm. And there's also a new state law does it take effect the same day as the federal law, or do you know that?
Yes, the new House Bill 2641 does go into effect November 12th, absent any federal changes to that hemp definition.
If there is a federal change and that's being actively discussed, would it
Mhm.
automatically change the effective date of the state law?
It would change the provisions of the state law. So currently what the bill says is that on November 12th, all the hemp-derived cannabinoid products will be considered marijuana under the definition of marijuana in Article 14, and therefore be regulated as marijuana under Article 14. But if there are changes in the federal definition of hemp, then hemp-derived beverages will not be included within that marijuana definition. And all other hemp-derived cannabinoid products would still fall under that definition of marijuana on November 12th.
Okay, that's if there's a change in the federal law.
If there is no change, then all hemp-derived cannabinoid products would fall under that marijuana definition.
Okay. And so all hemp-derived cannabinoid products would only be sold in licensed marijuana dispensaries from that point forward, right?
Yes.
And does that apply to CBD?
I would have to double check that definition. I think I'm not 100% sure because of the definition is a little bit long and kind of has language on both inclusion and exclusion. So I would have to double check that.
Okay. One of the questions that I always ask when I have an opportunity to talk to anyone from DCR is what are the chances that more comprehensive licenses will be issued? As you certainly know, the Constitution mandates certain minimum numbers, and DCR has chosen to stick close to those minimum numbers at this point. It's been court mandated to go a little bit above them for a variety of reasons. But has there been discussion at DCR of issue, and I think in the context of the fact that marijuana sales, and I have a clipping here somewhere, but marijuana sales in Missouri continue to set new records almost every month. There are massive amounts of marijuana being sold in the state. It might seem to suggest that it would be appropriate for there to be additional licenses issued. Has there been discussion of that?
Yeah, so that is something we think about because it is discussed in Article 14 that under certain market and economic conditions, the department would be required to increase their license limit. However, we right now, as of this moment, don't have exact data on these market and economic conditions, which is actually one of the reasons why we are doing this current market and economic impact study that we have contracted out, which we are expecting to get results for at the end of the year. So the outcome of that study will help inform if we need to increase our limits or not based on what the data says the market condition is. But I think at the same time, we are also considering all these potential federal changes and want to also be weary about how that may affect the market as well before any decisions for increasing that limit.
Yes, we're in a strange and rapidly evolving situation right now. But one of the facts which I think is often overlooked is the fact that indeed all marijuana activity, medical or non-medical, maybe legal, even that which including that which is legal under state law, still violates federal law. I mean, what you're doing, what I'm doing, what all the dispensaries and all of the cultivators in Missouri are doing violates federal law. at this point, the Federal Department of Justice has chosen to refrain from prosecuting you and me and all of those folks out there. But does that make you at all uncomfortable?
For me, I mean, I have not, I guess, really thought about it that way. I think my understanding is that they also recently just essentially renewed that provision that prevented any federal dollars being used for enforcement. And I think with at least parts of the federal government showing some indication of support of rescheduling. I guess I have not been as worried in that sense.
Well, good. I don't mean to make you worried. I don't think prosecution is imminent, but it is. It's always a possibility until the federal law changes. It's also interesting that the United States Supreme Court unanimously just ruled that notwithstanding federal law, notwithstanding the fact that marijuana violates federal law, that they're going to allow cannabis consumers to possess and purchase firearms. So, no one knows for sure these days, really, I think, what exactly is and is not legal. There are some areas where there's greater certainty. I wanted to ask also, and this may be a question for Leslie, but is it possible to have, at least theoretically, is it possible to have both a micro license, wholesale and dispensary license, or are licensees limited to one or the other?
So at application, you have to choose one or the other. And then remember, an applicant's name can only show up on one application.
Mm-hmm. So the answer is no, I think, correct?
No, you have to choose one or the other.
Okay. All right. You mentioned that there's another webinar on Monday, and having attended one of your webinars, they're very informative. I think that, when you're doing those, you have a chance to not only to use your slides and PowerPoint, but also to go into somewhat more detail. So I want to urge people who are thinking about applying for micro licenses to attend that webinar. How can they do that?
I believe the registration is still on our website, that they could go on there, and that would be the only one that's available to register still. It's Monday evening from 6 to 8 p.m. Yeah, if they can't find it, they can always email that general inbox, that cannabisinfo@health.mo.gov. And they can always email me as well. I'm always happy to do that. So that's leslie.turek@health.mo.gov. And I will also help with that if necessary. We generally close the registration at about 3 or 4 o'clock so we can get the information out to everybody. But yeah, you email me or that general and we will make sure you get registered.
And the website again is what address?
Cannabis.mo.gov.
Great, very good. I think I recall from when I attended your Jefferson City presentation that you made an interesting point about the many interesting points, but specifically one about the eligibility criteria of having, I think, either attended or graduated from an unaccredited school.
Yes.
Do I recall correctly that there are no unaccredited schools any longer?
There isn't any in Missouri at this time. Missouri hasn't had an unaccredited school since 2018. So there are 2 different criteria that are connected to unaccredited school districts. One is that the applicant graduated from an unaccredited school district. So if you graduated before 2018, it would stand to reason that's a possibility. And we do have a listing of all of those on our website, so you can see which school districts were unaccredited at the time. And then the other one is residency based, and it's within the last 5 years. So within the last 5 years, a Missouri resident would not be able, because we don't have any unaccredited school districts within the last 5 years.
That's what I was referring to. All right, that's what I thought I recalled. So I mean, someone who's old enough to have attended one when they were unaccredited might still be eligible, correct?
Yes, absolutely.
Very good, very good. Well, I wanted to ask for your thoughts on another matter. That is money, which makes the world go round. Financing, capital for capitalism. Those who want to be micro licensees, at least in some of the qualifying categories, by definition, must be relatively poor people. And yet, when they apply for a micro license, they're applying for the opportunity to invest a substantial amount of money in opening a business that complies with all of the requirements. And I think I heard you mention earlier that while the department is concerned about what it regards as predatory agreements with investors, that you're not opposed to investment agreements per se. Could you expand on that a little bit?
Sure. I mean, the reality is it's very expensive. I said before, it's a really highly regulated industry. It's also a very expensive industry to become a part of.
Mhm.
And to open a facility is very costly. I know a lot of people want me to make a breakdown of the cost. I can't possibly do that because all of the licensees I currently work with, they've been incredibly creative in how they've financed or in how they've opened their facilities and made sure that they were compliant and had all of the necessary equipment or things that needed to meet compliance. So I'm, first of all, very impressed with all the current licensees and how they've made it to where they are. So that's a realization I think a lot of people have to come to before they even apply is, how am I going to finance this? In what way?
Mhm.
I can't possibly tell you, I'd love to say there's so many investors out there and there's so many opportunities. There are, you just have to do a lot of legwork to find those people. So I do know that there are investment agreements that are absolutely okay. They meet compliance with DCR. I think it's that key of it cannot take away that more than 50% ownership, both financial interest and voting interest from the eligible individual for the life of the license. They have to maintain that. It also cannot take away operational control. So the eligible individual has to have that decision-making power within the license. They're the ones that have to be able to, if you're going to work with a manager, you have to be, if you're the eligible owner, you have to be able to fire that manager if necessary. I hope that's not necessary, but things happen. You have to be able to hire new people. You have to be able to have a say in how the business is run day to day. That's just part of that owning and operating requirement that we have.
Is it possible that more than one qualifying individual could form a partnership and apply and say the partnership, the qualifying individuals have majority control, but they might also incorporate a non-qualifying investor? Is that an option?
Yes, of course. You can actually have more than one qualifying individual, and they would both be contributing to the majority ownership of the license. And you can have many people who want to invest, and they can have smaller amounts of ownership interest. Remember, it's that 50% or more. That's really important. That whoever is qualifying, whoever's claiming the eligibility criteria, have to own 50% or more.
Okay. Now, I want to call to people's attention to the fact that some of us live in jurisdictions, zip codes, I guess it is, where any adult, at least I think you have to be an adult, maybe any person in that zip code is eligible to apply because of the historical sentencing on marijuana offenses. It's really complicated, but DCR has taken the complicated part out. You all have determined which zip codes would qualify people for merely living in that zip code. Is that right?
Yes. So we have several residency-based criterias, and one of them has to do with the historic rate of marijuana incarcerations, and that it's 50% higher than the rest of the state.
Mhm.
So we have done that legwork with the data, and we get that information from the Missouri State Highway Patrol.
Mhm.
And then we have a listing. It's both in the CSR as well as on our website of all of the zip codes that qualify for that particular one. As well as the other residency criteria that we have, we've also done the legwork for Missouri residents. If you're out of state, you have to do that legwork yourself. It can be a little daunting, but it's possible. But the unemployment rate, the poverty level, the unaccredited school districts, things like that, we've already gone to the U.S. Census Bureau, and we've collected the information for both zip codes and census tracts, because the law does provide for both. Article 14 provided for both zip code and census tracts. And we've gone to the U.S. Census Bureau website. We've collected that information for the state of Missouri. And then we have on our website, it's currently on there now, there's a table that lists everything. And you can search just for your zip code or just for your census tract. And I do encourage anybody who is wanting to use one of the residency-based criteria to check both zip code and census tract. Because we have noticed that in the last round that there were some applicants that did not qualify under zip code, but they did qualify under census tract. So checking both of those is really important so that you can make sure that you meet the correct standards for that criteria.
Very good. And I was surprised to find that right here in good old Boone County, the central zip code 65201 is one of those. So, I mean, if you live in the 65201 zip code, you're eligible. And it appears to me, if I recall correctly, it appears that those who live in a jurisdiction or live in a zip code or census tract that has a courthouse or has a county seat in it, they're far more likely to qualify, because nobody's getting sentenced for marijuana. Well, some cities have their own ordinances, but basically people who get sentenced for marijuana offenses are generally in a city where there's a courthouse, where there's a county seat. So I suspect that's true throughout the state, that your odds of being in one of those automatically eligible jurisdictions increases if you're living near a county courthouse. Is that your impression?
Yes, correct. Yeah. And all of that data comes from Missouri State Highway Patrol.
Very good. Very good. Well, let's see here. I think that covers most of the questions I have in my notes, and I've just checked online. I'm not seeing any additional questions from viewers yet. Are there any points that you, Leslie, or Dr. Yu, that you would like to add in closing?
I do get a lot of questions about conversion from a micro business license to a comprehensive license. So let me just touch on that really quickly. There is a provision within Article 14 that says if DCR opens up those, because right now we're a closed license state, so we're not issuing any other comprehensive licenses at this time. So if we determine that, as Rika was saying before, that the economic market can't sustain additional licenses, and we decide to open those up, 50% of any new licenses have to go to micro business licensees. Now, with that being said, it has to be licensees that have been operational for a year and are in good standing with DCR. So not in any sort of compliance issues or violations with DCR at the time. So I tell all of my licensees, you got to get to operational first before you worry about converting to anything. You got to move forward and get to operation. Micro business licensees have 2 years to become operational once they receive a license. So once that license is issued, there are 2 years that you have to be able to get your facility up and running and ask for approval to operate from DCR. Conversion is not going to happen automatically. So if a micro business licensee does want to do that, there is a lottery process for that as well. And then to make up for that 50% of the new comprehensive licenses, if and when available. So there is another process that will go through that. I tell everybody, hey, let's not worry about that right now. Hey, let's worry about getting the micro business market up and running. Because the reality is right now, I have 5 dispensaries that are approved to operate across the state. And that's exciting. We had 2 or 3 for a long time, but now we have 5. And I have 18 wholesalers right now that are approved to operate. All of those wholesalers are growing. I have a handful that are manufacturing, not many, because manufacturing equipment is very expensive. And so they're trying to figure all of that out and balance that out together. But there are new products that are coming out all of the time. So I think the reality is that we need to get the whole micro business market up and running before we ever start thinking about converting or wanting to move towards a comprehensive market. We've also had discussions at DCR that if that does happen and we start seeing some micro business licensees move, wanting to move to the comprehensive market, when the opportunity arises, we will have to issue additional licenses. We don't have plans for that right now because, as Rika said, it's going to take some time to evaluate the market to make sure that we can sustain all of this. But that is something that's a possibility in the future. I just don't know how far in the future.
Of course. Is DCR doing that study? I know, Doctor, you talked about it, but I didn't catch who's doing the study.
So this was contracted out through a request for proposal bidding process, I think sometime last summer. And the contract for doing this work was awarded to Cannabis Public Policy Consulting.
And who are they? Where are they?
I believe they are a New York-based consulting group, and as their name suggests, they have mainly been doing cannabis market studies throughout the U.S. and different states.
I'm sorry, where are they located again?
I believe they're New York-based.
Okay. Okay, fine. Maybe one of the most important questions I want to touch on with both of you is the dispensing of tax revenue from adult use sales, but also from medical use sales. The 2018 medical constitutional amendment required a 4% sales tax on all marijuana sold under Section 1 of Article 14, and that applies to medical users. And all that money goes to veterans services, not only healthcare, but other veterans services. Under Section 2 of Article 14, as you know, of course, the 6% statewide sales tax is required to be divided in 3 parts and to benefit, again, veteran services, because we anticipated a reduction in medical sales after adult use sales were legalized, and also 1/3 to science-based addiction treatment and 1/3 to the Missouri Public Defender System. Now, the Missouri auditor came out with a report, I think it was in March of this year, pointing out that at that point, there was nearly $100 million just sitting there in an account unappropriated by the Missouri General Assembly. And I think the auditor said even if the pending budget is approved, there's still going to be something like $60 million sitting there. Do you know, is that accurate? And do you know why the legislature has failed to appropriate that money as the Constitution mandates?
I think I will just reiterate the comments we left in our response in the auditor's report, which essentially was we didn't have any comments to add to that because that particular note by the auditor was addressed towards the General Assembly.
Yes, yes. But what I've just outlined is essentially accurate, correct? There is $60 million in marijuana tax money sitting unused at this point.
At
least that's what the auditor says, right?
that is what the auditor's office says. Again, granted, I'm not our finance person.
Right, me neither. Me neither. But that's, to me, that sounds concerning. I mean, I can't imagine why the legislature, especially in a time of limited funding, would fail to appropriate that money as the people of Missouri told them to do. So again, I'm not asking you to comment, but I'm just, for the benefit of our listeners, we may litigate, we may sue the state of Missouri to make it do what the Constitution requires it to do in that regard, and maybe in some other regards as well. But as I just said a moment ago, are there any additional points you'd like to make before we wrap up this session?
I think I will just make a note of, I hope we learn some interesting things about the hearing that starts on Monday.
Oh, yes, absolutely. Yeah, I'm sure we will. I'm sure we will. All right then. And Leslie, anything you want to add?
If anyone's interested in applying for the microbusiness market, please look at our website for more information. Or if you have questions, contact me. It's an amazing group of people. And I've said this many times in the last month. They are very passionate about what they do within the microbusiness market. And they are very much a community. And they're very much looking forward to having new licensees.
That's great. Well, thank you both very, very much. We really do appreciate you taking time out of your Saturday to be with us, and thank you for the good work you're doing.
Thank you.
Thank you.
Bye.
Folks, we have just heard from two of the major staff members at the Division of Cannabis Regulation here in Missouri. Dr. Rita Yu, the Director of Policy for the Missouri Division of Cannabis Regulation, and Leslie Turek, the Chief Equity Officer for the DCR as well. Now we're scheduled to have with us at this point Mr. Craig Katz, an attorney who is with the Missouri Hemp Trade Association, and Mr. Katz confirmed he'd be with us, but I just don't see him in the waiting room. The virtual waiting room, of course. So fortunately, we have someone who can speak almost endlessly about marijuana, and that would be me. I anticipated I might have to fill some time during the past half hour, but fortunately, our two guests from DCR had plenty of valuable information to share to fill that half hour, which originally had been allotted to some members of the Missouri General Assembly, all of which had to back out. But I know they had good reasons for doing that, and all of them have been supporters of marijuana law reform. Those include David Tyson Smith, representative from right here in Boone County and a fellow criminal defense attorney. David has a very good understanding of the law and the courts. And you know, there are relatively few lawyers down there in the General Assembly these days. And not that long ago, most members of the legislature were lawyers. And that would kind of make sense since they're making law. One would think that lawyers might have especially appropriate training for that. But for whatever reason, relatively few lawyers have run for the General Assembly in recent years. So David Tyson Smith is a very valuable member of the General Assembly. And speaking as a criminal defense lawyer, I'm especially pleased that we have a lawyer who does focus his practice, I believe, at least a large portion of it is criminal defense work. Also, Mr. Greg Bush, I believe he may be the only registered nurse presently serving in the Missouri General Assembly. So Greg also brings a very valuable perspective to the work he does in Jefferson City. Greg is a longtime friend of mine, used to assist me on my Tuesday evening radio program on KOPN. I've been doing that program now for some 27 years. It's sobering to realize how long that's been going on. But if any of you are interested in hearing that program, and I typically have guests, including many of the guests on today's program, on my radio show on Tuesday evenings at 7 p.m. on KOPN. And you can, if you're not in the mid-Missouri region where you can actually get the broadcast signal at 89.5 FM, you can hear that program anywhere, literally these days around the globe, by going to KOPN's website, kopn.org, and the program Sex, Drugs, and Civil Liberties is live streamed as it happens, as it is broadcast. It's also available by live streaming at kopn.org. Well, Greg has been, as I say, used to assist me with the running the board. I'm not capable of walking and chewing gum simultaneously. So unlike others, I need somebody to help me with the board in order to focus on what I'm trying to do and what I'm trying to say. And Greg was very helpful to me in that regard. And finally, Adrian Adrian Plank, who we really hoped would be able to join us. Adrian has been especially valuable to NORML and especially deserves our gratitude and support. He is a longtime Mid-Missourian, but he has been willing to file for us almost any bill we've asked him to file. And so Adrian has been the sponsor on behalf of and at the behest of Missouri NORML. Adrian has sponsored about a half dozen bills for us each year for the past, I think now 4 or 5 years. And these include bills to improve on legalization. Again, some people think, oh, it's legal now, we've got everything we need. Well, we don't. There are still people being arrested for a variety of reasons and relating to cannabis, unfortunately. For instance, one of the bills that Adrian has filed on our behalf is a bill that would permit patients who are students at state universities and colleges to possess and use their medicine when they're on campus. There's really no reason that should not be permitted. I mean, students at universities and colleges routinely possess and consume far more dangerous, far more addictive, and potentially deadly drugs. Opioids there's no restriction on the possession and use of opioid drugs by students at our universities. And yet, some schools, including the wonderful University of Missouri here in Columbia, have presumed to pronounce a policy forbidding any student from possessing cannabis on campus, even if it is authorized by a physician and by the state of Missouri. So we think we should change that law, and we could change that law. Adrian has filed bills to do that. He has also filed bills which would, just as New York State has done since they legalized several years ago, would permit cannabis to be consumed in any location where tobacco can be legally consumed. And again, that really just makes sense if you think about it. Tobacco is far more addictive, far more deadly, far more dangerous than cannabis is or ever was. There is absolutely no reason why cannabis should not be able to be consumed in any location where tobacco can be consumed. Now, I would favor leaving it up to an individual business owner to make that determination, I suppose. But nonetheless, I think it makes absolute sense to allow cannabis consumption where tobacco consumption is allowed. Some people don't like the smell of either one, and that's too bad, and they can go to another location. But certainly that ought to be up, I think, to the business owner or the private property owner. And if a public entity allows tobacco use, that public entity should be required to also allow cannabis use. Adrian has filed, as I say, several bills on our behalf in recent years that would improve. He's filed a bill, for instance, that would require the Department of Health and Senior Services, through the Division of Cannabis Regulation, to issue more licenses. Now, we strongly believe at NORML that competition works, that competition results in lower prices and more efficient operations. That's the whole notion behind capitalism. And you know, to the extent that we are capitalists, that we believe in capitalism, then we certainly should also believe that competition is good. Competition is a good thing. Competition benefits consumers. Our concern is with the welfare of consumers. And for that reason, we have encouraged additional competition, additional licenses to be issued. As I just mentioned during our conversation with the ladies from the Division of Cannabis Regulation, it continues to be reported, and it would seem month after month that the sales of cannabis in Missouri are, to say the least, robust. Actually, we're setting new records for the amount of cannabis being sold in this state almost every month. And again, I do have that clipping nearby here. $135 million was the monthly record-setting amount sold during the month of May. The average price of cannabis items sold, in other words, what they really mean, the average amount of an individual purchase, the price of individual purchases of cannabis products actually dropped from May of 25 to May of 26 by about $1 and some change. Not a dramatic reduction in the amount of individual sale. But what's more important is more people purchased cannabis, more than enough to make up for that relatively small drop in the amount of the average sale of cannabis products. And indeed, the Missouri cannabis market posted another milestone in May of 26, reaching a record $135.07 million in monthly sales, as many mature cannabis markets across the country continue to struggle with flat or declining revenue. This is reporting from MJ Biz Daily, a national news source, and I suspect it is inspired by, if not lifting directly from the reporting of Rebecca Rivas at the Missouri Independent. But MJ Biz Daily goes on to say that May sales included 124 million in adult use products and 10.83 million in medical marijuana sales. So, of course, as we anticipated when we proposed Section 2 of Article 14, when we proposed to legalize adult use generally, that resulted in a reduction of the amount of medical marijuana sold. And that's happened in every jurisdiction, all of the 24 jurisdictions, which originally had medical sales only and then transitioned into adult use sales as well. And it's simply because some of the people who are qualifying, who would qualify and do qualify for medical marijuana use, just choose not to go to the trouble of going back to a doctor and the expense of going back to a doctor and seeking another approval, another recommendation every year. Now, it was every year until Section 2 passed. One of the things that we did in the passing of Section 2 was to revise a few of the points in Section 1, the medical section passed in 2018. And one of those that we revised was to make a medical marijuana card good for 3 years instead of just 1 year. And that made perfect sense. People with a chronic medical condition, for the most part, don't get cured of that condition. If it's a chronic medical condition, if it's insomnia, if it's chronic pain from most sources, it's likely to continue. And making people go back to their doctor every year made no sense. And so I'm glad that we did implement that change. Nonetheless, again, medical sales are approximately 1/12 of the non-medical adult use sales. But May of this year, last month, was the strongest month in the history of Missouri marijuana sales. Adult use sales and daily sales averages, according to the Department of Health and Senior Services, average price of a purchase again dropped by just a little over $1, $1.18. But I think that is just not even significant, considering the fact that the overall sales continue to grow. Retailers averaged 4.36 million sales per day across the state in April. The new monthly high illustrates Missouri's status as one of the more resilient state marijuana markets in the U.S. While growth is slowing from the early boom that followed the February of 23 beginning of adult use sales, Missouri is still expanding at a time when several other states are experiencing pronounced softness. In other words, lower sales. Michigan, which is, I think, still the #1 state in the nation in terms of legal marijuana sales, but their sales are dropping somewhat. Adult use sales rose 5.69% year over year in Missouri. Through the first 5 months, Missouri sales totaled $641 million, well over $500 million, up very close to 2% from the amount sold during that same period, the first 5 months of 2025. Adult use sales accounted for $582 million in 2025. But I want to move on to some other topics here. I'm really hoping that Craig Katz will join us. I don't have a way of contacting Craig right now. I hope he didn't just forget about us, but he did confirm that he would be with us. And I've had Craig as a guest on my radio program several times. He's always been reliable. He's always shown up when he said he would. So I'm gonna jump to several other topics here. You know, one of the things about being a member of NORML. One of the benefits of that status is that you will receive once a week, unless there's some very urgent matter coming up. But once a week, typically on Thursdays, you will receive a weekly news update from NORML. It will include the most interesting, the most important news from around the nation and sometimes from around the world. And the most up-to-date scientific and medical research studies with links to the original full text of the study in almost every case. If anyone doubts NORML's summary of those studies is accurate, I invite you to go to the full text of the study itself, and we make it easy to do exactly that. Otherwise, Paul Armentano, our Deputy National Director, typically reads these studies. He keeps up with the scientific and medical literature on marijuana, and he is a very capable writer, and he is capable of translating highly technical scientific and medical jargon into language that everyday people can understand. So with that in mind, I want to share with you some of the stories that were issued this week, just 2 days ago, by the National NORML Office. You will get, if you sign up, you can go to norml.org right now. I urge you to make at least a small contribution financially. But the truth is, if you just go there and put your name in, put your email in, you will receive the NORML weekend weed read. And you can see this was dated 6/27. So the weekend weed read this weekend includes some of the following studies. One, a survey that shows that nearly 10% of US adults say they use cannabis to promote sleep. Well, I can relate to that. And others that I'm close to can relate to that. Indeed, cannabis is a great sleep aid with virtually no side effects or certainly no hangover. But according to a study from Richmond, Virginia, nearly 10% of US adults say they currently use cannabis to help them sleep. That's a quote from the study, according to survey data published in the journal Sleep Health. Researchers affiliated with Virginia Commonwealth University and the National Sleep Foundation surveyed a nationally representative sample of US adults. 1 in 5 respondents acknowledged having consumed cannabis products to help with sleep specifically. 9% of respondents say they currently use marijuana for that purpose. So 20% have used it at some point in their lives. 10% almost 10% continue to do so. Among respondents with no current or past cannabis use, 11% expressed interest in using it for the purpose of sleep and promoting the ability to sleep. Cannabis use for sleep, this is a quote, is rising in popularity in the United States, the study's authors concluded. The present study observed that about 20% of US adults currently use or have used cannabis as a sleep aid, with younger and middle-aged adults being more likely than older adults to use cannabis as a sleep aid. Future studies which examine cannabis as a sleeping aid in an experimental and clinical context are needed to inform public health and clinical recommendations. Survey data published in 2023 reported that as many as 80% of consumers report using cannabis as a substitute for other conventional sleeping aids, including medication, melatonin, benzodiazepines, or what's often known as Valium. Those are potent sleeping aids, but benzodiazepines have some terrible potential side effects, including addiction, dependence, and can easily be misused or can easily be taken in dosages which result in negative side effects. Cannabis does not. Melatonin is probably a little more benign than benzodiazepines, but nonetheless, melatonin for many people simply doesn't work as well as cannabis. Men and young adults are most likely to use cannabis as a sleep aid. Observational data finds that the enactment of adult use legalization is associated with a decline in the sales of other over-the-counter sleep medications. So that would make sense, and that is entirely consistent. According to the recently published review of 18 studies assessing cannabinoids in sleep, cannabis products contained elevated quantities of either CBN or CBD, in other words, cannabinol or cannabidiol. are associated with increases in total sleep time. And of course, those who are seeking help with sleep often seek out indica strains of cannabis, which you can use the mnemonic device, the remembering device of indica and in the couch, or into couch if you're using indica. But sativa tends to be a more energizing high. The result of sativa use is typically a more stimulated response and not a sleep response. Well, another study in this week's Weekend Weed Read is from Alaska. A bill becomes law providing record sealing relief for those with past marijuana convictions. So this is consistent with what's happening across the nation. Expungement is increasing, and right here in Missouri, expungement opportunities are increasing. If you have a past criminal conviction, even if you have an SIS, that can haunt you. A suspended imposition of sentence probation in Missouri means the defendant has, in almost every case, has pled guilty. It can follow a trial conviction, but that's extremely rare. The defendant may have pled guilty to an offense. The court has placed the defendant on probation, but has suspended the imposing of a sentence. That's very important for two reasons under Missouri law. If you have not been sentenced, you have not been convicted. Literally, legally, truthfully, you are not convicted if you're on SIS probation, and you never will be once you successfully complete an SIS probation. And the other major benefit of SIS probation is that automatically, within a very short time after you finish your SIS probation, without getting revoked, of course, the courts will automatically close, the court clerks will automatically close and seal the records of your case. There'll be nothing to indicate the case ever happened on the public record. But even after an SIS probation has been completed, there is still a record, and it is available to cops and to prosecutors and occasionally to other nefarious government entities, which may indeed use it against you in a future prosecution or in some other context. The other reason why it makes sense to pursue an expungement, even if you had an SIS probation, but especially if you did not, is that even SIS probation records are accessible by prospective employers in jobs involving care of children or elderly or disabled people. Under Missouri law, in the state of Missouri, in other words, if you apply to be a nursing home worker or a dental assistant or a teacher at kindergarten or grade school or high school level, and many other jobs that are deemed to involve care of elderly, disabled people or children, then that prospective employer is going to find that SIS record. If you expunge it, they won't. Now, the law doesn't say you cannot work in those fields. It simply says that the employer gets to see your SIS record if you apply to work in one of those areas. And so that's a very good reason to seek an expungement, even though you may have an SIS and you think it's been closed and sealed. Or I've heard some people come to me and I say, well, now what prior convictions do you have? And they say none. I say, well, now do you have any SISs? Because they're right. Technically, those are not convictions. They'll say, yeah, but that's been wiped off my record. Well, we don't just have one record, folks. We have multiple records, and we have multiple government records, and we have multiple Missouri records. And while an SIS may indeed eliminate a case from the public record, from the case.net public record that everyone can access, it does not eliminate it from the closed records available to cops and prosecutors. So again, I suggest if you have any doubt about it, if you have a prior case, even if it's not a conviction technically, that you think about taking advantage of Missouri's expungement laws. Now, there was a bill in the Missouri General Assembly this year, which I really was hoping would pass, which would have provided for much broader automatic expungement of a wide variety of criminal offenses. And I think they're building on, well, I know that they're building on what we established in Article 2 or rather Section 2 of Article 14. We established automatic expungement of almost all marijuana offenses, automatic from the point of view of the defendant. not from the point of view of the circuit clerks. We know they have to actually do work. They created these records and they have to uncreate these records. But they have almost unlimited money to do that. That $60 million sitting in a bank account right now can be spent to hire extra staff to finish these expungements. And despite what some clerks seem to think, that ain't rocket science. Yes, you can take a reasonably intelligent person off the street and train them within a reasonable time to do this expungement work. I don't know why some clerks are just fixated on the idea that this is so horribly complex that you just can't take a person off the street and train them how to do this work. You can indeed do exactly that. And it ought to be done, and it must be done. So we are sitting now at about 155,000 expungements across the state of Missouri. People who have had their marijuana offenses, the vast majority of those, 99%, I suspect, have been automatically expunged. In other words, the defendant did not have to lift a finger, didn't have to go to court, didn't have to talk to a lawyer or hire a lawyer. The court clerks have done those expungements, and they like to pretend that they're done. They managed to get the Missouri Independent to print a story saying, "Oh, we're almost done with expungements." Well, what they're almost done with is the easy ones. That is to say, the electronically recorded expungements since roughly 2000. And in some counties, it went on for several more years, but basically roughly around 2000, most Missouri counties began to convert from paper records to digital records. And as we all moved into the 21st century, those records were relatively easy to access, relatively easy, therefore, to expunge. But that's not what the Constitution requires. It requires much more than that. It requires that all, there's no exception, that all marijuana offenses, there's no time limit, there's no date that it begins. Twice now, I've seen a circuit clerk quoted as saying, "Oh, marijuana prohibition, that began in 1972. I wish that were true, but it ain't." Anybody who was around in 1972 is well aware of the fact that people were getting busted for pot from many years before that. The reality is that marijuana prohibition in Missouri began roughly around 1918. And it began with outlawing hashish dens in St. Louis. And whether there were any dens or not, the legislature was determined that there should not be any. And so they passed that law, and soon it expanded to a prohibition on the use of cannabis in any way, shape, or form. And that law has been on the books for much closer to 100 years, not 50, not since 1972, but much closer to 100 years. And the courts and the court clerks need to go back to those dates, need to go back to the early 20th century. And I don't care if the defendant's dead. The Constitution doesn't say that only living people's records should be expunged. There's no requirement that you have not reached room temperature. Even those who have assumed room temperature or have long ago left this earth, shuffled off this mortal coil, as Shakespeare would say, even those people are entitled to posthumous expungement. And we're going, as Joe Bondi mentioned, with his able assistance, we and I may undertake some litigation to cause that to happen. Well, we're rapidly approaching 4:30 p.m. and I don't see Samantha Blum waiting to be admitted to the meeting either. So I'm getting a little worried. Brandon, I don't know if you can hear me, if you're listening, but have you heard anything from Craig Katz? Have you heard anything from Samantha Blum? I know we sent them the agenda. We sent them the link. They confirmed their availability. I hate to just ramble on, but I'm totally capable of doing that. Brandon, would you see if you can reach again? If you can hear my voice right now, would you please see if you can reach Samantha Bloom, or for that matter, Craig Katz? We might be able to still put him on. I'm going to try to reach Brandon in just a little bit here and ask him to do that. I really had hoped that both of those folks would be with us because they both have really important information to convey. So now I'm calling our tech guy. Yeah, hey Brandon, I need to talk to you. I need you to try to reach Craig Katz and especially Samantha Bloom and remind them that they're supposed to be with us on this meeting right now. Would you please do that? And would you please leave your phone on so I can reach you? Thank you. Well, we'll see, folks. We'll see what transpires. I am really concerned. I'm texting Brandon now. But there is no shortage of information, so I will once again share with you some more information which came from this week's monthly, or rather weekly weekend read from NORML, while we hope Samantha Bloom will be joining us shortly here. One of the other stories which the national office highlighted this week is Virginia lawmakers approve budget language regulating adult use sales in 2027. And this is a big story, even outside of Virginia, because Virginia is a unique situation. First off, Virginia is the first of the old South states, of the former Confederate states, to legalize marijuana. And Virginia did that. At least a couple of years ago, maybe 3 or 4 years ago, Virginia's legislature legalized personal use of cannabis. But their legislature has had a very difficult time legalizing adult use sales. The last governor of the state of Virginia was extremely hostile to any effort to allow legalized sales of cannabis. His successor ran on a platform of claiming that she would sign a bill to legalize adult use sales. Well, the legislature passed it and she vetoed it. And I attribute that to her having worked at the CIA previously, only half joking there. But when you run for office on an explicit platform that you're going to sign a piece of legislation and then you veto it, that causes voters to be disappointed. Governor Abigail Spanberger is the individual who ran on a platform of endorsing legalized sales. NORML and Virginia NORML were instrumental in the passage of this new bill, which has now apparently gained the support of the governor. NORML's state director in Virginia and our national staff development person, J.M. Pittini, said that Virginia voters have made clear for years that they want a regulated retail cannabis market. With this budget agreement, the Commonwealth has taken an important step toward aligning state law with public opinion and replacing an unregulated marketplace with one that better serves consumers, strengthens public safety, and provides clearer rules for businesses, regulators, and local communities. Market regulations were included in budget legislation approved by the House and the Senate. Passage came days after lawmakers and Governor Spanberger agreed to revisions in the bill. The governor had previously vetoed a standalone version of the bill. Her veto elicited significant pushback, that's putting it kindly, from both Democratic lawmakers and from voters and from NORML, some 60% of whom consistently support allowing retail sales. And I won't go through all the details, but I'm just reciting this as an example of some of the information you'll receive on a weekly basis. If you sign up on NORML's website, go to norml.org. There's no A in NORML, NORML.org. Go to NORML, sign up, make a contribution, please, while you're at it. You can at least afford to kick in a few bucks, and join in the effort to represent the interests of cannabis consumers. Another article in this week's weekend weed read is from Alaska, where a bill has become law providing record sealing relief. And again, I've already talked about that, about the expungement provisions under the Missouri law. In Vermont, another article in the weekend weed read, the governor has signed a bill into law raising adult use marijuana possession limits. And Republican Governor Phil Scott there has signed a bill into law increasing the amount of cannabis retailers may sell to a customer in a single transaction and doubling the amount an adult may legally possess in public. Under the new law, which took effect upon passage, those aged 21 or older may purchase up to 2 ounces of botanical cannabis from a state licensed retailer. They may also possess up to 2 ounces and or up to 10 grams of hashish. Yeah, I don't know if that includes other forms of concentrated cannabis or not. Those thresholds are double the state's previous limits. State law already permits adults to possess greater amounts in private if it comes from their own personal harvest. Vermont is the third state this year to significantly increase adult use marijuana possession limits. Massachusetts and Illinois have also doubled their possession limits for adults. These changes reflect the reality that lawmakers in adult use states are growing more comfortable with legalization as time passes, says NORML's Deputy Director Paul Armentano. So it's good to hear of progress in other states. Kevin Caldwell from MPP talked to us about this earlier today, and did a great job of summarizing some of these developments in other states. You know, the Hamani case is really remarkable, and I think it bears talking about a little more. You know, I'm not a big gun fan. I don't own any firearms at this point. I'm not saying I wouldn't ever, but I do strongly believe that cannabis consumers have a right to be treated just as others are treated and not discriminated against solely because of their cannabis consumption. And that's exactly what federal law did until this unanimous decision from the United States Supreme Court was handed down recently. The ruling on June 18 in United States versus Hemani, Hemani, that's the defendant's name. In that case, the High Court determined that efforts by the federal government to categorically ban firearm ownership or possession for people with a history of marijuana use violates the Second Amendment. And that is precisely the position that was urged by NORML, by the group of lawyers who put together a friend of the court brief, an amicus brief. Joe Bondi led that effort, assisted by David Holland, an outstanding criminal defense lawyer from New York City, and 3 or 4 of us hangers-on also made small contributions. Justices rejected arguments that the government ban was rooted in historical precedent or that cannabis consumers are either categorically or unusually dangerous. And that phrase is in quotes. That phrase is a key holding here, that they're not categorically or unusually dangerous. It's not saying they're not dangerous, but at least they're not categorically dangerous or unusually dangerous. These fine lines, of course, are what the legal racket is all about. The majority opinion said the federal government asks us to conclude that anyone who regularly uses marijuana is categorically violent and dangerous without any further showing. Specifically, the government maintains that it may automatically strip Mr. Hamani of his Second Amendment right to possess a firearm because he uses marijuana a few times a week. More than that, because he possessed a gun, despite that prohibition, the government insists that it may imprison him for up to 15 years and disarm him for life, all based on little more than its current say-so, one at odds with its own regulatory actions, affording the government that kind of broad power to designate any group as dangerous and thereby disqualify its members from having a gun would risk allowing it to quickly swallow the entire Second Amendment. And Joe was quoted saying today's decision is a measured but important vindication of personal freedom and constitutional principle. The court recognized what NORML urged, that responsible adults do not forfeit their Second Amendment rights merely because they consume cannabis. And that is, of course, the truth. That helps to be on the side of the truth. The truth should matter. Hey, we got Samantha Blum. All right. Well, I'm so relieved you won't have to listen to me any longer, or at least the moment. Samantha, can you hear me? Come in, Samantha. Do you read me?
Yes, I'm here.
Well, you're out there. I can hear you breathing. Yes. Well, if you don't mind, turn on your camera and join us and tell us, please, about the Micro Business Licensing Association and its activities, and what those who may be applying for micro licenses in the near future might expect.
So I'm a round one winner from the first round of micro licensing that went out. Was drawn third in District 4, and we have been operational since September of 2025.
Where is that?
Uh,
Where are you?
I am in District 4, so I am in a very rural area in the middle of nowhere.
Well, there must be some towns around. What towns are you near?
Harrisonville is, I guess, about the closest. I don't like to give my exact location. But it's,
You're south of Kansas City. Would that be fair to say?
yes, we're about an hour-ish south of Kansas City. Yep.
Okay, go ahead.
So when DCR put together round one, I don't think that they were quite as prepared for it as obviously they were for round two and clearly for round three. And with that, we didn't actually have like a meeting or a get together or anything like that until about 6 months after our licenses were drawn. So we didn't really have an opportunity to meet and greet and all that kind of thing. So we had a couple of licensees that actually did that, got us all together. We all met for the first time in Columbia, in between the mandatory meeting from the state and all of that. So we sat down and chatted and decided that we needed our own voice. So that's how the MMBA.
By we, you mean those who received micro licenses?
Yes. So those of us who had won in round one got together, met each other. Some brought family, some brought their team, got to know each other. We started discussing like the different trade associations out there and how we kind of needed our own voice in the room. So we created the Missouri Micro Business Association. So I was a part of the organizing body of that, and then was voted into the at-large seat where I became the chairwoman of that association. We have been running for 2 years now. So we're actually in the middle of nominations and getting ready to vote for a new board. Everybody's allowed to run again, so I'm not sure what that looks like yet. But just a way to give resources to each other, give us a connection and a community, keep us together. Whenever the licenses, when it was in talks of it being written into legislation, whenever they were putting together the recreational, I did a lot of research on other states and kind of why they failed or didn't fail, why they did well, why they didn't do well. Kind of looked at what they were looking at putting into the rules and what they weren't putting into the rules. And I have to say that, and I've had a lot of people echo the same thoughts, that a lot of the things that were put into rule were kind of like they picked the best of what was happening in the other states. But one of the things that I noticed very heavily and why there wasn't a lot of success associated with the states that were coming up is they viewed each other as competition rather than a community, an ecosystem. So with the comprehensives, they can buy each other out. They can eat each other more or less. With us as micros, you have to be a qualifying applicant in order to have a license. We can't eat each other. We can, if we compete and we squash each other out, then you don't have enough product for the dispensaries. And then the dispensaries are going to suffer, and then the dispensaries are going to go under, and then you're going to have nobody to sell to, and then it doesn't matter, and then the ecosystem doesn't exist. So it is a very delicate balance and cycle that needs to be honored and understood. So while we are trying to make money and we are all in the same boat, there's no reason that we should be throwing anybody overboard. We really need each other to swim, or if too many sink, we're going to end up in a situation where there's going to be no one to sell it to and nobody to work with. So it's really important, at least to me anyways, to make sure that we kept that community and that conversation and resources and all of that flowing. So I'm really excited that they announced round 3. I'm really looking forward to having more dispensary licenses out there. That's been our biggest complication because we just had our 4th one commence and open its doors, and being operational with only 3. My hats off to those who were cultivators when there's only 1 or 2 dispensaries, because I don't know how they kept their doors open and their lights on, to be completely honest.
Can you tell us where those 4 operating micro licenses are?
Yeah, so our very first dispensary that commenced was it was Kush 21 down in Poplar Bluff. They were not the first to open their doors. Our second to commence was 816 Dispensary, who was the first to open their doors.
What's the name of that one?
Sorry,
816 was the first.
816 Dispensary, yes, and they are located in Platte City. They were the first to open their doors, and they opened their doors with only 1 cultivator on the shelves, which was Bloom Cannabis. And then the third was Grassroots, and they are in Cape Girardeau. And then our 4th to come online within the last week or so is the Rooster State Line, and they are in Platte City as well, right on the state line between Kansas and Missouri.
I see.
So we also have quite a few, I want to say at least 3 other dispensaries that are in the pipeline right now that are either really, really close, just buttoning up everything. We do have another one that is commenced as well, Dank Dispensary, and they are not opening their doors yet. They are waiting until there is enough diversity of products, which is something that we are lacking because we do not have enough manufacturers, and the manufacturers that we have are busy manufacturing their own products. They don't really have the time to, because we're such small teams, to manufacture other people's products. And because we're small teams, we're not pumping out enough to keep them on the shelves. So
Where will Dank be located?
they are, I don't remember the exact location. I think St. Peter's is where they are.
Oh, great, great.
Yes.
You know, I think it's ironic and kind of interesting that we have 2 micros operating in Platte City, because the Platte County prosecutor is the most hostile prosecutor to marijuana in the state of Missouri. Eric Zahn. I know Eric. I don't dislike him personally at all. But he has gone way out of his way to campaign against marijuana. So I think it's just great that there's 2 micros operating right there in Platte City. I've been by 816. It's a beautiful store, very nice operation. We had hoped to have Jimmy Poe, who operates that, with us today, but he was not able to be here. So we're happy to have you with us, Samantha. And are you, you say you are a licensee, are you a cultivation licensee?
Yes, so I'm a wholesale. I am commenced for both cultivation and manufacturing. We do both.
Great, good. And yeah, as you say, one of the problems, I would call it a problem, with the way that we wrote the micro license law is it provides for twice as many cultivators as it does dispensaries. And so that would seem to result in a surplus of cannabis, and at least at this point where we have so few micro dispensaries operating, it probably makes it very difficult for the cultivators.
Yes and no. I think that we'll get to a point where there's going to be so many that we won't be able to be in every store, So, I mean, even at the amount of plants capped at 250, even if you grow the biggest plants that you possibly can, and most of us are not, we're not at capacity. I know in my greenhouse, we can hold about 220 plants. And with that, we did do that our first round. And
Right.
as a small team of 3 people, and we do have 2 additional who can come in, they had to take a month off of work in order to come help us, and that was detrimental to their, their daily lives. So it was not financially something that we can afford to do, and we can't hire out. So this round we learned a huge lesson, and we scaled back to only doing 120 plants, which we're doing again for our next round, and so on and so forth. We will eventually get to a point where there's enough dispensaries where we can have the full amount of plants, but we grow in a greenhouse, so we don't have different flower rooms, we don't have a bedroom, we don't have a mom room, we just have one room. We pop seeds in a nursery, and then we put our seedlings right out into the greenhouse, and they go straight from there until they get harvested. So there are other places that have indoor, and they have more space as well, but even some of the other cultivators aren't even maxing out their 250 because they don't have enough storage, and they also don't want anything sitting on the shelves too long because there's not enough dispensaries to offload to. So, but I do think we'll reach a point where even at 250 plants, there's not going to be enough product per cultivator to be in every single dispensary anyways. So and also, there are a lot of people who are, not a lot, but there are a handful that have no intention of growing at all, that they purely intend to just manufacture and work with the other micros and buy from them their fresh frozen or biomass or whatever, and just manufacture and white label as well as full out purchase and make their own line through using other people's
I've always thought
products.
the greenhouses were the logical way to go. I admire you for using a greenhouse. I think that makes perfect sense. Certainly gives you a lot lower electric bill, and just seems to me that ecologically it makes sense all around. But people like me who are not farmers, even though I grew up on a farm, but I think a lot of us tend to underestimate the amount of work. I mean, there's a lot of hard physical work involved in successfully cultivating a large number of cannabis plants. Now, are most of the people involved in manufacturing, are they mostly manufacturing vape cartridges, or is it edibles, or what kinds of products dominate the manufactured products?
I think it's pretty diverse in that there's some doing some carts and gummies. There's some just strictly focusing on carts and infusing pre-rolls and not doing gummies at all, and doing wax. We are doing infused pre-rolls. We have really kind of stepped into the flower and pre-roll space. We are looking to expand with this round, our first round, due to finances. I qualified because I didn't have money, so that income. So my husband, or well, we're not married. My significant other cashed in his 401k and his entire retirement to invest into our company. So that is how we financed it. He had a full-time job and all of that. I've been a stay-at-home mom for the last 13, 14 years, homeschooling our kids. So I haven't really, I don't have anything saved up or anything like that. So that's part of why we went the greenhouse way. But I will kind of go to what you said, that people don't understand about the amount of plants. We were legacy growers before this, and to go from your small scale tents to stepping into a 60 by 80 greenhouse and having 220 plants is kind of overwhelming. But as far as what is on the market, there's not a lot of super huge variety, but there is a little bit of gummies. They go quick. There's a little bit of I think only 2 companies doing carts right now, only one doing live rosin. There's no distillate, as far as I'm aware of, at the moment on the market at all. There is, and then, like I said, the very sparing infused pre-roll market. We infuse ours, we paint the outside, and then roll them in hash, or not hash. We roll them in quiche and then keep and package them, so they are they sparkle. So but it's it's not a lot of variety in the market. A lot of it is flour and pre-rolls and stuff like that right now. There are more manufacturings coming online. We have one that I think is waiting on their ATO right now, that is ready to go, and quite, I think 2 or 3 that are, one that's trying to figure it out, and then who has already commenced, and then we have one that is getting closer and closer every day. We're just rooting for them to get across the line, and it'll definitely start to see a lot more diversity. We have another one that they're called South O Bones. They have 2 separate lines that they are going to bring to the market. One's Flow State and one's Prism, because one is grown in a deep water culture system and one is grown in living soil. They will be manufacturing, and they'll be bringing honey to the market, as well as live rosin and other things like that. So they are working towards that that product line coming out and launching and stuff. So it's a slow trickle. And especially in the micro, it's a very big chicken and egg kind of situation, like who comes first, but you can't really open a dispensary without wholesalers, and us as wholesalers can't really keep going if we don't have the influx of CASA purchases from dispensaries. So it just kind of goes back and forth between how we balance it, because we don't want too many dispensaries coming online all at once and not enough cultivators, because then there's not enough product, and then the dispensaries are going to be sitting open with nothing on their shelves because there's not enough dispensaries. So I know a lot of the dispensaries are or wholesalers are kind of keeping a pulse on that. We talk about it often, who's coming online and stuff, so that way they can start ramping up their plant counts in order to meet those needs. But a large majority of us are not even hitting the 250 plant count yet, just to be on the safe side.
Mhm. Yes, we had some comments from people from the Division of Cannabis Regulation earlier this afternoon, and they made the point that micro cultivators can have up to 250 flowering plants at a time, but you could also have plants which are not yet in the flowering stage. So the limitation is not as strict. And but as you pointed out, you don't need to exploit that yet, at least. We hope you will soon. From our point of view, from NORML's point of view, we believe micro licensees are important to the market because they provide competition with the so-called comprehensive license holders. Now, they've set a record last month, a record for monthly sales, 135 million across the state. There is plenty of business to go around, and we want to see the micro licensees succeed. We want to see you all do well. And so, we really want the state to issue more comprehensive licenses. And of course, you guys will be first in line for those comprehensive licenses under the Constitution, under Article 14, as we wrote it. And so, that's exactly what we hope to see is more competition in the market, lower prices for consumers, and more options, more services for consumers as well. So we really do wish you the best. How can people contact the Micro Business Association? How can they get involved or learn more about the work that you're doing?
The best way is, so I'm going to say this, and I'm hoping that it's not too soon. We are putting a website out. It is more focused on the micro businesses than it is the association itself. But we do have a page for how you can contact the licensees and stuff, and those board members, as well as the brands. And then you'll have links to their socials and stuff. I also write for Evolution every month, giving a snapshot, or it's either like a catch up of what's happening, or it's a story about a micro. The one in July is about South O Bones, and honestly, that has to be, I say it every month, but it has to be one of, I think, the most touching ones that I've written. He's a veteran. He's actually a declarated veteran, as well as his history, just his legacy in the market, and the name is about his dad, and it's just it's really beautiful. I think that's my favorite part, honestly, is getting to know and meet these people and stuff. But it's pretty sure the website's going to be MissouriMicrobusiness.org is how you can find us. It's not launched yet. We're hoping to launch it soon. We're just putting the finishing touches on it. There will be like a contact us, or you can email us at microbusinessassociation@gmail.com. That goes to the board as a whole, or you can reach out to any of the board members, myself, whatever it is that anybody needs. That's a big thing as board members is we keep ourselves open, and if anybody needs any help, we offer everything that we possibly can, resources. We do monthly webinars where we get people of all kinds of calibers. One of my favorite calls was just last month where we had a genetics call. We had 3 different geneticists come on, and it was just such a beautiful call to hear like 3 people from, it wasn't competitive or anything. It wasn't salesy. It was just like the conversation was so genuine, and like you could feel the love that everybody had for talking about genetics and the questions that were answered. And it was just like such a fun call to be a part of. But we do those to spread education. We've got one coming up in August that's all about different vendors for dispensaries and stuff. So that way our up and coming dispensaries, if they don't know who Dutchie is, or, the different opportunities or leaf link or weed maps or, things like that, how they can get involved and connect those things. And back to you mentioned that 50% of the comprehensive licenses, if they open up, can be micro. I think that's a great opportunity for micros. Some of us are not interested. We want to stay micros. I think that it's a very niche place to be. And in the comprehensive market, you have to be very conscientious what you sell, because it's such a heavy competitive market. Where in the micro market, I feel like we get the opportunity to take a lot more risks, and we get to make really fun, interesting new things, because we're trying to draw people in to try new things and to come in and have a reason to come outside of the fact that it's craft and hand touched and all of those different things. So I like that about being a micro, is it really opens the door to that creativity and risk taking, because they're small batches. It's not like it's millions of dollars worth of cannabis that we're throwing away if it doesn't work out. So
Well, that's great. And that's exactly what we had hoped when we drafted the micro business provisions in Article 14. So let me say, if I can be of help, if Missouri NORML can be of help to you guys at any time in any way, please don't hesitate to call on us.
absolutely, yes. We love to work with, talk with, be on, however we can help in general. Especially me personally, and anything that I can get involved in and help educate people. We say, like right now we have Roosters State Line. They, have people coming in and they don't understand 816 Jimmy. That's one of the hardest things that he says he comes up against is the education. What makes him different from a hemp shop or a comprehensive or this or that? It's educating people why there isn't that diversity on the products yet. It's educating why to keep coming back, and so on and so forth. So I came up with a brochure that we can hand out at events, and that Jimmy's been handing out at his store as well, that kind of teaches people why a micro, what is a micro, what is the social equity aspect of it, and stuff like that, to kind of make it easier to spread that education. So any opportunity I can to spread that education, and other people can spread that education as well, is important, because it's not another yacht or a condo that you're helping buy. It's literally for me, it's putting my kids through softball. It's, they play all the sports. I have 4 daughters. One just graduated high school. I have an 11-year-old and a 7-year-old, so I still have more working their way on up. It's truly mom and pop. It is helping, fund things that matter for our future, and it's also, we help, while our kids do not go in or interact with the plant, we garden and, stuff outside, and they understand the importance of nature and this life cycle and stuff. And so it's cool that when they get older, like our 18-year-old who graduated high school, she's like, I can't wait to be 21. I can't wait to come work with you guys. I am so excited, blah, blah, blah. So like even seeing that, like the future of what cannabis can look like and whatnot is important too. And so that's education, learning
All
about
right. Thank you.
about all of it. So yeah.
Thank you, Samantha, very much. We appreciate you being with us this afternoon. Have a
Yep.
great evening.
You too. Thank you.
You bet. Good luck. Our next speaker, folks, our final speaker of the day is Morgan Fox. Morgan has been active in the marijuana law reform movement for many, many years, and NORML is very lucky to have had him on our staff for the past several years. Morgan is highly qualified to represent cannabis consumers in the U.S. Congress and in other federal venues, other federal concerns, including the upcoming rescheduling hearings. Morgan's going to talk to us about that, as well as about legislation that's pending in the United States Congress. Morgan, thank you for being with us. There you are.
Dan, thanks for having me. I honestly really want to get as many questions from you and the audience as possible, because right now we're in a situation that is relatively unprecedented.
All right.
When you're looking at the executive order that Todd Blanche put out a couple of months ago, it basically said that the exact same substance is either going to be Schedule 1 or Schedule 3 based on how it's treated under law at the state level, which is unprecedented for any other Schedule 3 substance, and also that none of these substances are FDA approved. So we're already in a very gray area when it comes to cannabis policy and the rescheduling order. But then you also have to look at what has been going on with the actual rescheduling hearing, or the broader rescheduling hearing for cannabis. As you know, NORML applied to be a representative and a witness in that hearing, and we were denied, which I think is pretty egregious, not being allowed to represent consumers at a hearing that will definitely impact consumers. But this hearing was completely stacked against the proposed rule. The government is even having a hard time figuring out exactly how they're going to defend the supposed proposed rule that they are supposed to defend, but that the DEA really doesn't want to pass, and has shown since 1972, when NORML first applied to move cannabis to out of Schedule 1, it's become just increasingly clear that the DEA wants to keep cannabis in Schedule 1. So now the outcome of these hearings are going to be very interesting. And we're also seeing litigation against even the rule that made state licensed medical cannabis products legal. We're seeing a lot of confusion in the marketplace right now. So honestly, we don't know exactly what is going to happen. There's rules that Blanche has asserted could be overturned. The hearing could go nowhere or be wrapped up in litigation for years. So we really don't know exactly what is going to happen. What we do know is that clearly the deck is stacked against us. And what we also know is that there is a concerted effort against any sort of transparency. Unlike the previous hearing, there is going to be no live streaming allowed. There are going to be only a handful of witnesses allowed in the room that are not directly involved in the case. And this is very detrimental. I mean, this is a huge case. Even though Schedule 3 is certainly not the be-all, end-all of where we want cannabis policy reform to go, people need to know what's going on in those hearings and hear exactly what folks are saying for and against, so that we can respond to it and so that we can continue to do our work. And the fact that despite protestations from media, from NORML, from a number of other advocacy groups, from members of Congress like Steve Cohen, we still have basically no access other than just people's recollections after the hearing. So we'll see what happens.
What may happen, if I understand correctly, what may happen ultimately is that non-medical adult use cannabis may be rescheduled to Schedule 3. I mean, is that the essence of the proposed rule?
Essentially, yes. So the Attorney General's initial order automatically and unilaterally rescheduled state licensed cannabis products to Schedule 3. But again, it's unsure whether the AG actually has the legal authority to do so, and that's being challenged right now. My reading of the law is that they do, but there is certainly the ability to get standing from some of the people that have brought those lawsuits, and so we could see all of the progress that we've made derailed. And if there is even a temporary stay, I'm very curious about what that does to the application process, because the DEA did open up basically a get your 280E tax relief by applying through the DEA and by providing tons of information to them. But there's a lot of lack of clarity there as well. They're asking a lot of questions of operators, but there's no information about exactly what sort of their production quotas are going to be, what their production caps are going to be, whether or not there's going to be increased interest on the part of law enforcement for people that continue to operate under state license systems, but that don't get DEA licenses. There's way more questions than answers. And I was at the Cannabis Regulators Association conference just a couple of weeks ago, and these regulators are not getting that much information from the DEA either. And so their hands are tied. They don't know what to tell operators. They don't know what to tell consumers. It's really a total mess. The fact is that a lot of people really want to get that 280E tax relief, and rightly so. But at the same time, you're also giving the DEA a signed affidavit and confession that you're breaking Schedule I rules and violating federal law, as well as providing enough material to wrap everybody up in your organization in a conspiracy charge.
Yes. Well, I may have a bias, but I tend to think that the uncertainty comes from the top. That, in fact, Donald Trump is the one who has initiated these changes, but without having any real idea of what he's doing or what's going on. And so we all live at the mercy of Donald J. Trump. I mean, what seems really bizarre to me, and again, if I'm correct, I'm asking you, if I'm correct in my understanding, last year when the government shutdown was being resolved, the Trump administration at least supported, if not initiated, getting this ban on federal hemp-derived products incorporated into the budget, the shutdown resolution. And as of November 12, under that resolution, nationwide, all hemp-derived products would become illegal under federal law. And many states took that as a lead. And Missouri among them passed a bill which will also make hemp-derived products illegal under state law as of November 12. Well, in the last 48 hours, I've seen a couple of news stories that seem to say that the White House, read Trump, is changing his mind. Is that correct? Is that accurate?
Well, so this is an issue that came up over and over again, where a lot of people, when they were trying to get that bill across the finish line, they wanted to end the shutdown, and a lot of lawmakers were not actually reading too much about what was in it. And I've been talking to a lot of folks on the Hill who said, like, yeah, we signed it so that we could get the shutdown ended, but we didn't really realize that this provision was actually in it until after we had signed it. Your government at work, right?
Yes, not uncommon. People vote for
so
things
now,
they haven't read.
There are a lot of folks on the Hill that want to, at the very least, give a pause so that they can get their heads around the issue. And, I'm a little bit biased. I am kind of a one plant guy. I think that, we should be regulating all cannabinoids and not just like little individual silos. But at the same time, there are a lot of livelihoods at stake right now with the impending hemp ban. And there are a lot of folks who voted for the shutdown under consolidated bill that didn't really realize that this language was in it, and now are scrambling because significant portions of their own state's economies are depending on it.
I'm glad they are responding. Now, the thing here in Missouri, for instance, the Hemp Trade Association has actively lobbied for and had bills filed that would regulate them. They're not opposed to being regulated. They're begging to be regulated. And yet the licensed marijuana industry would only accept a total ban on any sales by anyone but them. And they won't really sell hemp derived products themselves. They don't care about them. They just don't want the competition. I mean, I may be cynical, but I think that's a fair read of what transpired here. So Congress could instead pass regulations of hemp derived products. They could put age limits on it. They could require testing and labeling and similar things to what every state that's legalized adult use requires of illegal marijuana sellers. Is there any talk of doing that, of imposing regulations on the hemp industry?
Absolutely. There's legislation that's currently being considered in the Senate right now. There are a number of bills on both the House and Senate side that either ask to delay the implementation of the total ban or to outright overturn it and actually implement decent regulation. But I feel like a lot of this is missing the point. So many lawmakers are talking about these, hemp derived to hemp synthesized products, and it's like they don't realize that cannabis is also in this conversation. We're talking about the chemically synthesized versions of compounds that are existing naturally in a plant. Why don't we just deschedule it altogether? And NORML's been pushing this for years and years now. The only policy that makes sense is full descheduling so that we can start a regulatory process that incorporates synthetic cannabinoids, that incorporates minor cannabinoids, that incorporates novel cannabinoids, and that stops people from going to jail. I think people have really kind of missed the mark when we're talking about this because money has gotten involved, and legitimately. The barriers to entry to getting involved in the hemp derived or hemp synthesized industry are much, much less, and so they do provide a lot more opportunities, especially for folks that have been left behind by the broader or licensed cannabis industry as it currently stands. But from a consumer perspective, from a legal perspective, we need to stop confusing lawmakers about this and just start talking about decriminalizing first and then descheduling cannabis across the board.
Exactly. That is consistently what NORML has advocated. But we also have to recognize that most political change is evolutionary and not revolutionary. And I think we have to, hold our noses perhaps, but embrace a step in the right direction. Embrace rescheduling of cannabis, but at the same time, make it clear this is not our ultimate goal. It's not really what we would favor in the long run.
Absolutely. I mean, incremental progress is progress nonetheless.
Yeah.
My worry is that we'll end up going down silos about individual products that will potentially confuse lawmakers. I mean, right now we're in a situation where conservative lawmakers are okay with decriminalizing or providing pathways for people to use hallucinogens, but are still super freaked out about cannabis.
Right.
And some of those same lawmakers are okay with synthetic hemp-derived cannabinoids, but they're not okay with natural plant cannabis and are still okay with arresting people for possessing small amounts of it. And so, I think that if we really look at the end goal and start pooling our collective resources and our collective ideologies together, we can make a lot more progress right now with the momentum that we have, with the fact that cannabinoid access is becoming more and more regular. And if we work together to weed out bad actors, making sure that people aren't selling, like garbage doping gas stations to teenagers, and work together to find regulations that are going to work for everybody, that protect existing businesses, that protect future businesses, it's going to be much better across the board. And, we don't have to necessarily worry about the intricacies of policy once we stop arresting people and start allowing for any sort of legitimate businesses and open markets. And now we're, because of this fracturing, our opponents are starting to take advantage of it. We're looking at repeal initiatives in Massachusetts this year, in Maine next year, and these are really, really serious threats to legalization, because while on the surface they're just repealing legal access, the ultimate goal is to repeal legalization entirely.
Sure. Yes, that seems pretty clear. So are there other states where there are repeal efforts alive? I mean, at one point, Arizona was considering some sort of repeal effort, I think.
There was, interestingly enough, the primary proponent of it was doing so at the behest of out-of-state actors. And once they actually looked at what the record was of Arizona businesses not selling to minors, not advertising to minors, decided to drop the initiative.
That's great. Yeah, Kevin Caldwell talked about that a little bit earlier. I was amazed. I didn't realize that actual logic and reason prevailed, and it turned out the person who was being used by the out-of-state actors was a reasonable person, and so that was a really inspiring story there, to know that that can happen. Meanwhile, up in Idaho, there's a bunch of idiots who are trying to deprive the voters of their ability to legalize. Is that right?
Absolutely. Hopefully we are going to see, actually, it might have already qualified, but we will see a medical cannabis ballot initiative in Idaho next year. But we're also going to be seeing a legislatively approved ballot initiative that basically strips voters of their right to ever change cannabis policy ever. Now, why any voter would vote for stripping themselves of their ability to vote on a particular issue is beyond me. But apparently, lawmakers think that that is a good use of their time and a good way to suborn all of the cannabis policy to themselves and not let voters actually have a voice in the issue.
Mm-hmm.
So it'll be interesting to see what happens if in the case that both of them pass.
Yes. Will they both be on the same ballot?
I believe so.
Okay, so that would be next year, not this year, correct?
Correct.
Well, it's going to be a low turnout election. There's not going to be much else on the ballot in 27. At least most states won't have much on the ballot.
Well, that's one of the things that actually scares me the most about Maine, because when you look at the history of cannabis policy reform ballot initiatives, they do the best during presidential election years.
That's right.
Off-year elections or midterms generally tend to bring out demographics that are less likely to support cannabis policy reform. And we're talking about older and more conservative voters. In off-year elections like 27, I mean, that's going to be bringing out people that are very issue specific and not many other people. So I think it's really incumbent on anybody that really cares about cannabis policy reform to make sure that they're mobilizing folks in Maine and Massachusetts right now to make sure that these repeal initiatives go down real hard. Because so far, no state has ever repealed really any significant part of their legalization law, and that's largely because they're working as intended. And I think it just goes to show that the only reason these things were able to get on the ballot is because the people that were gathering the signatures were misleading voters. There are numerous reports in Maine, Massachusetts, and Nevada, Maine, Massachusetts, and Nevada that show that signature gatherers were lying to voters about what they were signing when they were signing the petitions to get these things on the ballot. And when these things became public, especially in Massachusetts, the Secretary of the Commonwealth just said, "Don't worry about it. It's not enough proof to invalidate enough signatures to keep them off the ballot, so don't worry about it." And I think we can expect to see that same malfeasance in any sort of extemporaneous signature gathering that they need to do after the fact. In Massachusetts, I think they still have to submit, even though they've been cleared for the ballot by the courts. In Maine, I think they still have some more signatures to gather. I would expect to see similar initiatives popping up in other states because the people that are funding them have a huge war chest.
Yes, yes. Do we know where that war chest is coming from? Is this the pharmaceuticals? Is it the alcohol industry? Where is this money coming from?
I mean, there's a handful of mega donors that have always been very on board with providing funding where necessary, but also a lot of it is coming from drug testing industries
Oh, yeah.
and associations, addiction treatment associations.
Yes, yes, of course, of course.
You follow the money, right?
Right, exactly. But you mentioned Nevada. What has happened in Nevada?
Well, Nevada's going good. I misspoke.
Oh, okay, okay, okay. Well, Ohio is an unfortunate example of the people passing a legalization measure, and then the legislature starts whittling away at it. Do you know what has changed in Ohio?
Oh yeah, I'm from Cleveland,
Ah,
so I've been paying very close attention to what's going on in Ohio, and unfortunately, the state legislature is totally fine with stripping away rights that voters approved through issue two, through a measure called SB 56. They basically recriminalized a lot of behavior related to cannabis, almost entirely innocuous, and created additional criminal penalties for said behavior, and also tried to institute a sort of weird protectionism where if you cannot prove that you purchased or obtained that cannabis in Ohio, you are all of a sudden subject to criminal penalties, just like before when prohibition was the law of the land in that state. And the legislature, throughout the entirety of the discussions about this over the last couple of years, during which NORML was really beating the pavement and trying to get as many people as possible to reach out to their lawmakers and say, like, this is ridiculous, consistently said that, oh, this isn't actually going to hurt consumers. The media in Ohio didn't even pick up on it until the last week. And I think that this is really indicative of something that we need to watch out for as cannabis policy reformers across the board. The threats to the status quo, while it might not be perfect in any particular state, are always there, and they're going to start growing. There is funding available for people to challenge consumer rights across the board in any of these states. And we're going to start seeing more and more challenges to whittle away at the laws that both legislatures as well as voters have passed. Consistently over the last probably decade, it's become clear that our opponents cannot win the hearts and minds of the people, so they try to take away their voice. And now they're trying to actually do proactive ballot initiatives to overturn the laws that voters have passed and are resorting to trickery and malfeasance in order to convince them to do so.
yes. In fact, there's an effort here in Missouri to undo the ability of the people to pass constitutional amendment initiatives. In other words, to pass initiatives that the legislature cannot turn right around and repeal. So the legislature placed a measure on the ballot in August that would require it would make it tremendously difficult to pass any initiative. It would require a majority in each of the congressional districts, and almost nothing has ever achieved that majority before. So as small as 5% of the voters actually could defeat an initiative if that measure passes. We're trying right now to educate people as to why they should not vote to do that, but it's not as clear. It takes a little bit of knowledge about what this proposal really is and what it would really do. Now, I mean, there is a great deal of state activity across the country, and certainly what happens in the states has an impact on what happens in the U.S. Congress. But are there other bills pending in Congress? Are there other measures pending that may have an impact on cannabis consumers?
Well, the things that I've been paying the most close attention to when I'm up on the Hill are appropriations, because that is typically where we have had the most success, but also where we face the most threats at the present moment. So for a little bit over 10 years now, we've had language included in the Commerce, Justice, Science, and Appropriated and Related Agencies measure that protects state legal cannabis businesses from interference by the Department of Justice. It doesn't protect them from Department of Homeland Security, which we've seen in New Mexico, and oddly enough, almost solely in New Mexico. But I would not be surprised to see that spreading a little bit. But
what has happened in New Mexico, if you don't mind me interrupting you?
Oh, not at all. This is actually a really egregious issue. So, Customs and Border Patrol has jurisdiction in the United States within 100 miles of the U.S. border. And that means that at that 100-mile marker along any sort of border state, particularly the border of Mexico, there are checkpoints at that 100-mile marker. And so producers in the southern part of New Mexico moving legal shipments of cannabis products to distributors on the northern part of the state, not even crossing state lines, would have to go through that CBP checkpoint. And we've been seeing over the past couple of years, drivers getting stopped, getting temporarily incarcerated, and all products being seized. To the point now where I believe it's up to several $1 million worth of product that has been seized. And it's actually causing a problem for consumer access because folks don't want to produce in the southern part of the state. So they're having to move their entire operations at great expense. And people that are just individual consumers carrying small amounts of cannabis are petrified of going through those checkpoints, even though cannabis is legal in their state. It's legal south of that 100-mile line. It's legal north of that 100-mile line. They're not taking it out of state, but they are still liable for federal prosecution by just stopping at that checkpoint.
So is marijuana legal in Mexico? Is that what you're saying? Or
No,
south?
no, no. I'm talking about just within the state of New Mexico.
Just that line. I
Yeah,
understand.
and oddly enough, this is not happening in any other states, so it might just be an overzealous CBP administrator that's in charge of that particular state. But it's become enough of a concern that language has been included in appropriations bills to require Department of Homeland Security to release reports about any sort of seizures that they make that are of state legal cannabis products. We'll see if it goes anywhere. I mean, honestly, as much as appropriations is really the only vehicle where things are really going to move in the current session, I think it's very likely that we're going to get a continuing resolution because Congress does not want another shutdown before the elections. And they're already talking about it, but at the same time, we can't let up pressure on it. We need to continue trying to beef up the language that we already have in appropriations language. We need to continue trying to get rid of bad language, such as the language that bars the District of Columbia from actually regulating cannabis for adults, forcing it into an entirely medical system. The language that prevents veterans from being able to have VA doctors actually officially recommend medical cannabis to them under the auspices of state law.
Isn't there an effort to undo that? I mean, is there a bill pending to undo that?
Yeah, so we've seen that come up several times in either NDAA or in military construction language, and I think that we're going to see that language again on the House side and probably on the Senate side as well. What I'm really scared about is some of the amendatory language on the House side that would limit the scope of the protections that we talked about earlier for medical cannabis operators and patients that has been in place for more than a decade now. Last time that we went through this in appropriations, it got a little bit of support on the House side, but got no support on the Senate side. It wasn't included, and then did not end up being included in the final consolidated bill. I am not seeing any signs that it's going to be included in the Senate version this time, but in the House, it was included in the base language that was approved through both subcommittee and the main committee. And this language would restrict the Rohrabacher-Farr language that has protected medical cannabis businesses for many, many years now to anybody that is basically doing any sort of cannabis-related activity within 1,000 feet of a school, university, playground, or public housing unit, as well as other special use areas, would be exempt from the protections that Rohrabacher-Farr has provided for the last decade. And so that means like a patient growing a single plant, caregivers, B2B transfers that happen to be in those zones and get pulled over. The effect on state legal markets, if this is to pass, and the DOJ decides to utilize that that pass that they've been given to actually start beefing up prosecutions could be absolutely devastating to medical cannabis programs. And even if it's not being done practically, we haven't seen any sort of a rollback in this particular sphere yet. And this would be a significant rollback, which honestly puts us on the back foot in terms of getting better allowances in appropriations bills going forward. So hopefully we're going to see some of the folks in the Cannabis Caucus introduce strike measures when it does go to the floor, if it goes to the floor, and it's not just a clean continuing resolution in order to avoid a government shutdown. But aside from that, we are seeing steady reintroduction of a lot of interesting cannabis bills. Up until now, we saw a lot of standalone bills that were a little bit incremental. We were talking about housing bills, expungement bills that are a little bit, narrowly tailored. We've got bills that make sure that people that have been busted for cannabis are not invalidated from their ability to access SNAP benefits and things like that. On the opposing side, most of it seems to be industry focused. The bill that seems to be getting the most traction on the opposition side is a bill that would maintain the 280E tax code, even if cannabis is descheduled or rescheduled for all cannabis businesses. It's only got 12 co-sponsors, so I'm not too worried about it actually moving anywhere. But over the next couple of months, I expect to see a lot more cannabis policy reform initiatives or bills being introduced. And, I think it's incumbent on all of us to make sure that they have as many co-sponsors as possible. Leadership is clearly not going to move them. Leadership is actually opposed to even moving a delay for the hemp ban.
Even after the White House is calling for it? I mean, is there a chance that would change things?
Yeah, I mean, you saw that people that were like folks like Hal Rogers in appropriations were are Trump loyalists, but also introduced a rider in the Commerce and Justice and Science bill that would prevent the administration from actually changing the schedule of cannabis and would reserve that right solely to Congress in clear contravention of the White House order.
Yeah.
It seems like there are some lawmakers that are particularly anti-cannabis that feel like this is an issue that they can poke the president on, where in a lot of other issues they wouldn't dare poke the bear.
Mm-hmm. Exactly. That's not as if Trump has been radically pro-reform, but it's a bizarre situation. It's just bizarre. I mean, what other positive bills would you anticipate may be filed soon?
Well, we just did see the reintroduction in both chambers of the Safe Banking Act. I have yet to read the any sort of like technical changes in it, but again, I don't think that any standalone legislation really has too much of a chance of moving. But what we really need to do is build as many co-sponsors for all of these bills as possible, whether they be industry-related bills or purely social justice and criminal justice-related bills. My personal baby is the Marijuana Parity and Federally Assisted Housing Act, just because I get calls every single day from people that are being forced to choose between having a roof over their head and having medicine. But there are going to be a lot more bills coming down the pipe. We also just saw a new introduction of a brand new bill, the Educate Act, which would create grant programs for HBCUs and HSIs to study cannabis agriculture. We saw the bill that Representative Titus introduced a few months back that creates centers of excellence for universities and creates a number of opportunities for funding for cannabis research.
Well, that sounds promising. Missouri is moving toward greater research. We just had a guest from the Department of Health and Senior Services here. They're putting together the rules right now for research programs, which will include clinical research opportunities. And it sounds like it's relatively wide open that anyone can apply for a license to do cannabis research with people, with animals. They're actually it sounds like, promoting, doing good research here.
I mean,
But
from a scientific and agricultural perspective, the United States is getting lapped by other countries
that's
in
right.
Europe and Latin America, and this is a good way to really sell these programs and help eliminate some of the stigma while also providing opportunities for communities that have been traditionally targeted for enforcement under prohibition.
Speaking Speaking of which, I know the term HCBU, historically Black Colleges and Universities, HBCU, but what's HSI?
Hispanic serving institutions.
Oh, okay, of course, that makes sense. Okay, very good, very good. So this bill would specifically authorize those institutions to do cannabis research?
It creates specific grant programs that are funneled through those institutions.
Uh-huh.
And hopefully, we're going to see a federal expungement bill be introduced pretty soon.
Good.
But fingers crossed, we're going to see reintroduction of the Cannabis Administration and Opportunity Act in the next couple of months, so that we have a full descheduling bill that we can talk about on the Senate side. The MORE Act on the House side is continuing to gain co-sponsors. So, I mean, things are moving. It's just that leadership is never going to let these things come and get some air unless they're absolutely forced to.
Sure.
And I don't think that we're in a position to really force them to do so.
Not yet.
Especially since there's ideological issues with it. I mean, I've met with Mike Johnson's office before, and I could tell right away that they're giving me lip service and being very polite, but there's no chance in heck that they are ever going to bring any sort of cannabis-related bill to the floor if they can avoid it.
At least they're polite. But what many of us, of course, are hoping for is a shift in the majority party in the House, if not the Senate, this coming November. And if that were to occur, would that have a dramatic, fundamental, what's the term, paradigm shift impact on all of this?
Only if we ride them. Across the board and for decades now. No matter how much popular support there is for cannabis policy reform, it continues to be a low priority issue. And even among diehard supporters, there's several issues that are of greater importance above them. And the same thing is true for most lawmakers. So you have to really ride them to make sure that they know that this is actually an important issue. It's an issue that a lot of people care about. It's an issue that people do prioritize. And that by doing so, they can actually help themselves both politically as well as provide a better legacy for themselves, as opposed to, just kind of providing lip service.
Well, it seems to me the best opportunity to make that point to would-be Congress members is during the election. When they show up at a public forum, when they show up at any location where we have a chance to question them, I think we should all make a point of being very outspoken about telling them that our priority is marijuana law reform. There are just so many important opportunities to do that right now.
Yeah, and I mean, cannabis policy reform is a microcosm for much larger issues that we're dealing with as a society, and I think that everybody would be better off if we dealt with this one, and we can use it as a blueprint to deal with a lot of other issues. But you're absolutely right in terms of electoral politics. If we want cannabis policy reform to be a priority issue, there have to be consequences for ignoring it.
Yes.
And we need to make them felt at the ballot box. We need to make them felt in their email inboxes. We need to make sure that they know that when they make missteps or they ignore this issue or they deprioritize it, that people are thinking about that when they go to the ballot box in the next election.
Mm-hmm. Well, one of the things NORML does, I think, a great job of is helping people contact members of Congress. One can go to the NORML.org website anytime and find opportunities to send a message to legislators and to tell them what we believe is important. What else can people do? What else would you recommend people do?
Well, I mean, go to norml.org/act so you can actually directly contact your lawmakers. Also, anytime you are wanting to meet with your lawmakers directly, or you want any sort of advice or additional information or talking points, or just want to bone up on your education about it, feel free to contact me directly at morgan@norml.org, and I'm more than happy to help you and connect you with your lawmakers, make sure that you can get meetings scheduled. A lot of times, I only talk to staff because staff makes most of the decisions, but also because the actual lawmakers themselves really only want to talk to people that are going to potentially vote for them. So you want to come down to DC and you want to talk to your lawmaker, I'm happy to set up a meeting and help you out with that and go with it too.
Well, that's great, and that's very valuable. But I want to point out to folks that you don't have to go to Washington, D.C. to talk to your Congress members. You can see them right in their home district, and I think sometimes they're less distracted. They're less likely to interrupt the meeting with something else. And I think so many people assume they have to go to Washington to lobby, when in fact those legislators come to your home. They come to where you are quite often, and one can often set an appointment with their home office.
And just a lobbying tip for all the citizen lobbyists out there: the staffers are the ones that feed that information up to the top and eventually influence what decisions are made in terms of policy. Make good relations with the staffers. They might pop around to different offices and change jobs a lot, but a lot of them stay in that same sphere. So you might make a good relationship with somebody when they're working at lawmaker A's office, and then before you know it, they're in a higher position in lawmaker B's office, and then you've already got an in. So make good relations with those staffers, all you citizen lobbyists out there.
No doubt about it. No doubt about it. Well, Morgan, thank you so much for being with us this afternoon. I really appreciate a chance for our members and supporters here in Missouri to hear what you have to say, and look forward to working with you and seeing you at some NORML events in the near future, I hope.
Thanks very much for having me, Dan. Appreciate it. And again, anybody that wants to get more directly involved, go to norml.org/act. And if you have any questions about federal policy and to a lesser extent state policy, I try to keep up with it as much as I can. Feel free to contact me directly at morgan@norml.org.
Thank you, sir. Thanks again. Have a great evening. Folks, our guest has been Mr. Morgan Fox, the National Political Director at NORML, the National Organization for the Reform of Marijuana Laws. And Morgan has brought us up to speed on a lot of important issues, a lot of important matters that will be coming before the Congress, and the fact that we're facing serious threats of losing some of the victories we have won in the states. And so it's very important to fight on all fronts. I also want to tell you all that I did just get a message from Craig Katz of the Hemp Industry Association, and he's extremely apologetic, but he didn't just forget. His 91-year-old mother-in-law had emergency surgery for the second time in 3 weeks, and he was just unable to be with us. So I want you to know he didn't just blow us off. He had an extremely important personal medical emergency, not unlike the one we experienced a few weeks ago when we tried to do this conference earlier. But I'm very pleased. I think we had a great lineup of speakers today, and a great opportunity for all of us to learn much more about the state of marijuana law reform in the states and in the federal government. We can't overstate the fact that you should be a member of NORML. You should be on NORML's email list. You should go to norml.org and sign up for the weekly news updates. They're very, very valuable information. It will keep you apprised of what's taking place around the nation, around the world, and in the states. For those of you who are here in Missouri, we especially appreciate your engagement with NORML. We need your help. We need your support. It's all too easy to assume that, oh, we won the battle here in Missouri back in 22. And it was a tremendous victory. And we have moved so far in the last, the last 7-8 years since medical marijuana reform was passed by the voters in 2018. We've made tremendous progress. We have newfound credibility in the Missouri General Assembly. But we can't afford to rest on our laurels. We can't afford to just assume that it's all done now. The fact is there are many, many important reasons why NORML needs to continue to work on behalf of consumers, and why consumers should continue to support NORML, continue to support the work that we're doing, continue to spread the message that cannabis consumers' rights matter. And the industry is not going to make that case for us. The industry is not representing consumers. They're like any other industry. They are representing those who are in the business of growing, manufacturing, and selling marijuana products. And there's nothing wrong with that. That's as it should be. I like can trade. It's just that occasionally there are places where our interests and theirs diverge. And the establishment of the micro licensed industry is a very important aspect of that. The industry, the MoCan trade folks, compromised during the drafting of Article 14, in particular in regard to Section 2. They compromised in regard to allowing individuals to cultivate their own cannabis. That doesn't help the industry, by the way. They compromised in accepting the proposal for a minimum of 144 new micro licenses to be issued in the state of Missouri. And again, the term micro license is misleading. These businesses authorized under the micro licensing provisions of Article 14 are very robust businesses. Anyone can make a very good living operating a micro license dispensary or wholesale operation or manufacturing operation. As Samantha Blum pointed out earlier, some folks who hold micro licenses don't intend to do any cultivation. They intend only to manufacture products, and that is also authorized under the so-called wholesale licensing provisions of the micro license provisions of Article 14. Others will not manufacture any products. They will solely focus on cultivation. And of course, those who get a dispensary license will be focused on the retail operation. They're allowed to make pre-rolls, but they can't infuse those pre-rolls. They can't create infused products. They have to purchase those from those who have a license to manufacture and to cultivate cannabis products. So it's an interesting arrangement, but again, my point is that the licensed marijuana industry in our state was reasonable, was fair. They gave us the money that we needed. If it weren't for the licensed cannabis industry, we would never have had the money to gather the signatures to put this issue before the voters. We laid the foundation. We laid the foundation for legalization of marijuana here in Missouri with 50 years of activism, 50 years of holding conferences like this one, 50 years of talking to the news media, 50 years of going directly to the voters and letting them know that marijuana is not something they need to be afraid of. So many of the prohibitionists were able to stoke the fears, the irrational, unfounded fears of non-cannabis consumers about what would happen if we were to legalize marijuana. Well, now it's become much more difficult for them to use those same arguments. It's very difficult for them to argue, for instance, that your children are going to begin using marijuana if it's legalized for adults. We now know with solid evidence, with empirical data, that simply is a lie. It was never true. It was never. Kids don't care what adults are doing. Kids don't care whether marijuana is legal for adults or not. And we have seen dramatic reductions in the amount of marijuana used by young people in states like Colorado, one of the first to legalize marijuana use. And the use by kids in Colorado continues to drop. There is nowhere that there's been a significant or dramatic increase in marijuana use by children because of legalization. The opposite, if anything, the opposite appears to be true. Morgan has made a comment here in the chat, still listening apparently to me blathering on. It says home cultivation, in all caps, definitely helps the industry rather than hurting it. Well, that's an interesting concept. He says it's a low barrier incubator for innovation and skills that benefit the market and does not touch the retail bottom line. Well, perhaps. I'm not sure everybody in the industry here in Missouri recognizes that to be the case. I think some in the industry viewed it as a definite compromise when they allowed us to have what is a relatively strong home cultivation, personal cultivation option here in Missouri. And what we wrote was a bill that said you can have up to 6 flowering plants. Well, the state of Missouri, bless its heart, and the folks who were in charge at DHSS during the first couple of years after legalization passed, they knew that what we really meant was you can have 6 flowering plants, and you can have 6 seedlings or clones, and you can have 6 plants under 14 inches. But the bottom line is you can have 18 plants at a time, as long as they're in different stages of cultivation. And there aren't many other states that allow for home cultivators to have up to 18 plants. Missouri has a good home cultivation provision. Whether it helps or hurts the industry may be debated, but in fact, our industry embraced it and never tried to stop that from happening. They also did not try to stop the micro business industry from having a chance to compete with them. And that's what they do. 144 competing licenses will be issued by the state of Missouri, and the third round of micro business licensing is about to commence. And if my notes are correct, that will open on July 13 and continue through July 27. So 14 days during which anyone who qualifies under any of the 9 different categories, including living in 65201 area code, but there are many other ways to qualify. Anyone who does can file and submit an application. And the folks from DCR today assured us it's not complicated. You don't need to hire a consultant. You don't need to hire an attorney. They didn't actually say those words, but I think that's what they were implying, and they're right. It should not require a consultant or an attorney in order to submit a qualifying application for a micro business license. And once you are in that queue, once you're in the group of potential licensees, you'll have an equal opportunity with every other applicant to be drawn, to be selected. Now, you do have to submit, and they've raised the price a little now, a $1,600 and some dollar application fee, but that application fee will be refunded. It's not just refundable, it will be refunded if you fail to obtain a micro license. If you do obtain a micro license, that may be the best $1,600 you've ever spent in your life. A micro license, either for a dispensary or for wholesale, meaning cultivation and or manufacturing of cannabis products, can be extremely lucrative. They're not micro, folks. They're substantial, and they are potentially very profitable licenses to enter into the cannabis industry. And as Samantha Bloom pointed out, as others pointed out earlier, those who hold a micro license will be first in line, in fact, must receive at least 50% of any new comprehensive licenses issued by the state of Missouri. And we certainly hope and urge that the state will issue more licenses. That, again, is somewhere that we diverge from the position taken by MoCan Trade. It's okay. We can disagree about things like that. We can disagree about the role that intoxicating hemp products should play in the market. And we do disagree about that. MoCan Trade succeeded this year in convincing the legislature to pass a measure similar to the federal prohibition, which kicks in November 12, unless Congress changes it. And sounds like there's growing steam behind the movement to delay that implementation date and to regulate instead of prohibiting cannabis products. We hope the same thing will happen here in Missouri. I regret we didn't have a chance to hear from Craig Katz today, but I think that's exactly what Craig would have told us, that there is continued reason to hope that the hemp-derived industry in Missouri will survive and will be accommodated and regulated rather than prohibited under both federal and state law. That's what we believe is in the best interest of consumers. That's the reason NORML exists, to advance the interests of consumers. And we fully endorse the view that hemp-derived products should be strictly regulated. There should be age limits. There should be requirements for testing for both purity and potency, and there should be requirements for labeling reflecting that testing. But there should not be a prohibition on cannabis products, and that is precisely what the legislature has passed. It is disguised as a bill allowing only the licensed marijuana industry to manufacture, cultivate, and retail hemp-derived products. In fact, they won't do that. In fact, according to the fiscal note that was attached to a bill last year, and I haven't had a chance to look at the fiscal note on this year's bill, but the very first paragraph said, if this bill passes, no hemp products are going to be sold because it conflicts with what Article 14 of the Missouri Constitution requires. There's so many other things that we actually have not had time to talk about today. Other matters I'm sure that I will wish I had discussed with you further. The Missouri Supreme Court's decisions, which are just incomprehensible, which ignore and violate the language of the Missouri Constitution regarding expungement, are terrible. But there's no reason to lose hope. The Supreme Court could change its mind. The Missouri legislature could enact legislation. And again, the legislature has been receptive to measures which increase opportunities for expungement. And let me close on a high note. One of the good things that the Missouri General Assembly did this year, which I thought, frankly, didn't have a prayer, is a bill that is now or will shortly be signed by the governor, has been or will shortly be signed by the governor, which increases the franchise, the ability to vote for people who are on probation or on parole. Now, it'd be nice if people in prison could vote. And in fact, they do vote in Massachusetts, I understand. But for many years, Missouri has had one of the best re-enfranchisement laws in the nation. In many states, you can't vote after a felony conviction. In many states, you can only vote if you jump through a whole lot of administrative hoops and get an order from the governor or an order from a court. I mean, in many states, it's just very difficult to vote after a felony conviction. In Missouri, your right to vote is automatically restored as soon as you're off paper. That is to say, for the past many years, as soon as you're off probation or parole, your right to vote is automatically reinstated. You have to register, but that's all you have to do. Everybody has to register in order to vote. But now, with this new bill that was just passed this session, people can vote while they're on probation. People can vote while they're on parole. And I hope they're going to do it. And that was a very good bill passed by the Missouri General Assembly this year, which will improve life and improve the rights of those who have cannabis convictions as well as other types of convictions. We are on schedule. We are done for the day. I thank those of you who listened this afternoon. I thank those of you who may listen in the coming weeks and months and maybe even years while this recorded event is available on YouTube and on Facebook, as we intend to make it very shortly. So don't hesitate to come back and review anything that you've seen or catch those sessions you missed this afternoon. Thank you so much. Let's keep on fighting for the rights and the interests of cannabis consumers. Join NORML. Thank you.